We'll try that again. You have just watched for the last minute me talking constantly to the microphone while I was muted. Hello and welcome to Reading the Receipts. It's been a long week. Appreciate you being here, chat, on a off night like this. We've got a lot to fly through. We are going to cover, as always, the week's updates in the Justin Baldoni Blake Lively case. And I'm going to cover a lot of the docket stuff very, very quickly because I really want to get into the amicus briefs this week. This is what I just said on mute, so you're going to see a repeat for all of my lip readers. But I want to talk about why those amicus briefs are so important, why this case is so important for survivors of sexual harassment. I think that is going to take up the bulk of what we're going to talk about today. Chat, welcome in. Bellmoon, I can't hear. I am glad I caught that in the first minute, a couple of minutes, not 30 minutes in. That would have been fun. But hey, you get to practice your lip reading, I guess. Vandervee, good to see you, and the Junk Farm. Hey, we don't shame the mute round here. Yes. All right, so like I said, I'm going to fly through the docket. Before we do, our disclaimer, as always, this is not legal advice. I am not a lawyer, and I'm certainly not your lawyer. Everything that we're going to talk about tonight, the allegations that we're going to talk about are just that. They're allegations. Nothing has been proven in court. Nothing should be considered as a fact. This is all just my opinion provided for entertainment purposes. We shouldn't read too much into it. You're also going to hear a lot more alleged from me tonight as we talk about these other cases, just to make sure, doubly sure when I'm talking about this, that I am not stating things that are fact. I am stating a person's opinion or a person's recollection and telling of events, and we want to keep that in mind as we go through tonight. Our scientist, good to see you. That would have been hilarious. I don't know. I think I would have been a little disappointed to have done like 2 hours and then have to do it again, or just redub it. Maybe I could do that next time and just kind of do like the Kung Fu movie redubbing over the top. All right. So let's get into the dockets. So we're going to start out with James Vituscka, right? We ended off last week where Sloan had kind of produced this motion to compel to get that conversation from James Vituscka, the one that is used in all of Baldoni's filings, the one he's using as the foundational claim here that Leslie Sloan defamed Justin Baldoni, and then they refused to hand over that conversation. So James had asked for an extension. They have now had time to respond to it. I'm not going to go too deeply into it because it's kind of moot. It basically just repeats the idea that, firstly, they can get the conversation from Wayfarer. They shouldn't be asking us. And we've seen this argument a couple of times before, right? This is what we saw with the Edgeworth subpoena. It's what we saw with the Venable Taylor Swift's subpoena. That look, if you can get this information from parties to the lawsuit, you should get it from them. Of course, the problem is we know from Baldoni's own filings that he has been editing that conversation. So we cannot be 100% sure that the conversation that gets turned over by the Wayfarer parties is the unedited version rather than the edited version that they have been using in their later complaints. They don't match up with the early complaint. So which version of the conversation we got here? The one where you've taken out all of the incriminating messages? So that's the reason they've been asking Vituscka, but Vituscka still says, look, you should at least try and get them from them. And then, argues for the reporter's privilege, arguing that actually, even conversations that aren't used to make news articles are still covered by that reporter's exception, by that reporter's privilege, and stating that. So, and then he also says, look, it's overly broad. You want all of my conversations with Melissa Nathan without limit to any date or connection to the case in respect. I say that it's moot because Sloan then filed a letter, I think it was like 2 days later. Was that? He filed that on the 28th. No, it was the day after. Filed it the day after. Oh, the piece that we got in here was that between Sloan's motion to compel and Vituscka's, we learned that on May 27th, the parties engaged in a 90-minute meet and confer to resolve the subpoena. While parties made significant progress, the Sloan parties refused to withdraw or stay their alone motion to allow further narrowing before the issues before the court. Well, the day after, Sloan did indeed put a stay on that motion to compel to basically say, that they want to pause it until the June 5th, as Sloan and Vituscka have continued to negotiate a compromise wherein the Sloan parties would agree to a narrower set of documents, and Vituscka would agree to set forth key facts in a declaration. Such a resolution would obviate the need for court intervention. So it sounds like they're making a deal to get a smaller, narrower collection of documents. So maybe not all of the conversations with Melissa, Nathan. Maybe just the ones either just relating to Wayfarer and just relating to Leslie Sloan, but also getting Vituscka to put a declaration together, maybe stating that Sloan has never planted a story with him. Sloan never alleged that Baldoni had sexually assaulted or sexually harassed Blake Lively. That would be pretty damning for Wayfarer, because again, this is their foundational piece of evidence. And if Vituscka basically turns around and says they're not telling you the truth and puts that in a declaration, that kills their entire case against Leslie Sloan, at least. So yeah, we're going to see next week, hopefully, some movement on that. So he does say that his counsel's unavailable to the week of June 9th. So I'm not understanding why they're pausing to June 5th if they're saying his counsel is going to travel. Oh no, they're unavailable the week of. Okay, so they're going to negotiate up to June 5th, and then we'll see. The other thing that hit the docket, and I did get a message about this, and if you're watching this and you're the person that messaged me about this, I will be responding to your message as soon as we finish up here. But they'd asked me about a weird filing that had happened. So as you can see, we're in the 250s this week, on May 29th, 257 on the docket. But one of the items that appeared this week appeared further back, May 22nd. Where is it? 252 here. It's got a higher number on the docket, but it got dated back. I don't know why it's been held back a week, but it's a motion to intervene from Brett Douglas McDowell. I'm not going to cover this. I have my reasons. I will say the dockets are all public. The documents are all public on the docket. If you are interested, go read them. Brett is also very present, heavily present on X. There is a lot more background to his story there. You are welcome to go read and make up your own decisions. I have done exactly that. There's somebody who has tried to engage with me on social media. I've looked at their story, and my response was to completely disengage and not give any of this any oxygen. But you are welcome to go look and dig further. I will not be talking about it or covering it. All right. Milady says, "I'm awake, I just woke up." Carla Ferrer says, "Why do so many lawyers support Baldoni?" I don't know, and I wouldn't say that they do. I think a lot of lawyers have come out in favor of Lively. I think what you're talking about is a lot of content creators have supported Baldoni. There has been a big debate this week about the fact that a couple of the big creators that support Baldoni are misrepresenting their legal credentials. I think that's as much as I want to say on that. I have looked into it, and I know very much that they are misrepresenting their legal credentials. So yeah, I would just be very, 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 very careful of people who say that they are lawyers and have legal experience and have been pushing a particular viewpoint, because I think you will find as we go through these legal filings and we go through this this whole court case, they will not be accurate in their predictions. Right? A lot of them have argued that Lively's trying to settle, or her case will get dismissed, or Baldoni's will not get dismissed, and all of these things. I would simply say watch over the next coming weeks. I think you're going to find that they're not going to be right. I could be wrong. We may be here in a couple of weeks watching me say, "Hey, I got it completely wrong." And I don't know what I'm talking about, because I'm not somebody who's a legal expert. I don't have any legal education. And you're welcome, Carla, to come back then and tell me that you told me so. I haven't heard lawyers, basically content creators, says Belmoon. Yes, same. A lot of the lawyers have kind of sided about the strength of the case. And I think most people are very, very quiet because they would rather argue about the facts of the case rather than the endless PR spin. Okay, JonesWorks, they responded and finished up their motion to dismiss Wayfarer's amended complaints. I don't really want to cover this. I mean, this feels at this point just a repeat. right? Wayfarer's opposition to the motion to dismiss was essentially just, oh, this is Jennifer Abels. This is Jennifer Abels' opposition to the motion to dismiss. Her counterclaims about her having indemnification, that she's like any damages should be covered by Leslie, by JonesWorks' contract. It's strange to me, she's arguing that the employment contract is null and void while arguing that it isn't in the other case. There's not really a lot in here. It's just very much a redo and like a repeat. She doesn't really deal with a lot of JonesWorks' responses or corrections or points, whatever you want to say. And so, yeah, it just felt like a copy and paste and not really anything in it. So I don't really want to cover it because I didn't see anything that was like stood out and was a lot for it. But she basically says, nope, she's wrong. The employment contract that I had with JonesWorks is completely null and void and was null and void the moment it was written because of its competition against California law and its non-compete contract. So it made it completely null and void, the whole contract. And so she's only covered by California Labor Code, which would indemnify her for any work she did under Jones. Of course, I don't think that covers all of the fact that, again, she's not doing any work for Jones. She's actually going against Jones's wishes and all the rest of it, but we'll see. Again, even if she gets that indemnity, as I understand it from other lawyers, that then means that JonesWorks can choose her legal representation and pressure her into settling with Lively. So I'm not sure what her end result here is other than to try and get away from paying for damages. So we'll see. Katie Joy. Different Katie Joy? Or the Katie Joy? If so. I think a lot of influence lawyers support him because that's where the views are. My husband is an attorney who has worked on defamation and employment discriminations. The whole thing is very clear to him. I'd be interested in his thoughts and opinions there, Katie. Bellamy says only lawyers that Freedman represented and got settled. I think there are some other lawyers, but I get it. There's a lot of people who have worked with Freedman, should we say, that are very much on his side. Jugfarm says, I don't think Lively settles for all the money in the world. I think Jones takes all of Baldoni's money way before Lively gets a shot of it. I don't know. I think Jones probably would settle, I think. I don't think it's on her, especially with being in PR and having all of these clients, to really aggressively go after Baldoni. I think, I think a settlement and an admission of guilt, or like an apology or payback of the rest of the contract would be enough, but we'll see. I think Lively is motivated by, I think Lively is not motivated by money. She's after codifying protection, so what happened to her doesn't happen to others, says all scientists. Yes, and that is what we're definitely going to get into later on. Oh my God, different Katie Joy, I'm very much. Okay, but it's just you gotta say, like, got me. Which, if you're a fan of Reddit drama, I will just say that has been wonderful this week. Ashley says, hey, people on TikTok keep talking about a DC lawsuit. Is there any truth to that? I don't know. I think what you're talking about there, Ashley, to a DC lawsuit is the DC motion to quash that Venable filed. They got subpoenaed by Wayfarer for the whole business with the text messages between Taylor Swift's lawyers and Blake Lively's lawyers, and that was filed in DC District Court, I believe, because that's where Venable are on their local ground. They didn't have to go to New York. I think that's what you might be referring to. If you're not, if you know something else and it's different, then definitely let me know. I also think she wants to see the Nathan Wallace network exposed. Yeah, I think that's the real takeaway that's going to come away from this, is that exposure of those smear campaigns. But we'll see how it goes. All right. So yeah, the Able. This was the Abel's opposition. JonesWorks. Jones responded to both Wayfarer and Abel's amended counterclaims, filing her support for motion to dismiss, making that both of her motions to dismiss the amended counterclaims in the JonesWorks case are now fully pled. Again, the Wayfarer one, I mean, there's not a great deal in here from Jones. basically, again, a repeat, arguing that, look, they don't even allege, again, when they're talking about confidential information, they don't actually allege what was confidential. They're also trying to, you know, suggest this stuff. They say again that, you know, they're alleging that the confidential information was disclosed before the subpoena is pure conjecture based off the message from Sloan about I've seen the texts. But the point of, like, they don't know, they don't actually plead what information was disclosed to Sloan and that that would have been confidential information. They're just arguing that anything would be. So again, it's kind of a repeat and a do-over. They didn't plead harm. And then, you know, talking about they didn't contest the applicability of the speak out. I think it said that it didn't apply, but I don't remember at this point. But, you know, they also talk about Wayfarer's own performance was not excused. Again, you know, talking about they didn't at the time terminate the agreement because they knew of any purported disclosure. They terminated the agreement and then found about it afterwards. And so, you know, again, they didn't provide her any requisite notice or the opportunity to cure the agreement, which was also in the contract they had. So them just terminating and being done is itself a breach of their contract, is what JonesWorks is arguing. Again, kind of a repeat of what we've done. Going through about like the different law, again, insisting that New York has greater interest here. She talks about how, you know, they don't explain how their challenge statement is false. You know, they have to sign it. There's not a single text or email showing Jones discussing Wayfarer's smear campaign, and the only pertinent information, including Jones, shows that she was encouraging a positive approach. So they're saying, you know, again, that because she was copied on one of the emails, that she would have been part of any smear campaign. And she's saying, nope, I was telling you to take a positive approach, which again is all in Baldoni's own stuff. So yeah, and then going on to argue that don't give them any more excuses to amend because they've continued to fail to present anything that is actionable. We'll see. The Able one is a little more interesting. The Wayfarer one is a lot drier and just to the facts. The Able one kind of goes in for a little more damage. So that one we will spend a little bit of time going through. Jennifer Able changes her story so much it is hard to keep track of what her claims even are. So we're already starting off strong. This is telling because if her claims contained even a modicum of truth or factual basis, they would not and could not continually and constantly morph. Yet after multiple attempts, Able cannot, and in some cases doesn't even attempt, to support or explain the basis for her claims. And that's what we kind of go into. She, where are we? Doesn't actually allege what specifically was accessed, just that they obtained quote unquote data, but they, you know, that she had her personal data. She does not point to even a single example of a personal email, item of browsing history, photo, note, medical information, or financial information that JonesWorks allegedly accessed. Nor does she explain any basis for allegedly having come to understand that this has happened. So she's talking about, look, not only does she not allege what data I actually supposedly did, she can't even tell you how she knows that I did, which is another bigger problem of her claiming that she accessed her cloud accounts. Because again, if they just did a forensic extraction of data on the phone, it doesn't matter that data is copied to the cloud and is the same data. It was on the phone. It is on the company device that is owned by JonesWorks. She's protected. She also talks about, like, you know, she doesn't actually fully plead out her emotional distress either, and that, you know, she hasn't really fully pled the hacking statutes either. They point out that, you know, each of Abel's claims requires affirmative action on the part of JonesWorks, which is true. Can't be just a passive thing that JonesWorks did. Before any liability can attach, that is, that they require hacking. Abel alleges none, instead only making the conclusory allegation with no factual specificity or basis that JonesWorks, for example, had unrestricted access to everything stored on Abel's phone. I talked about this when I talked about like the interception case law on this computer stuff, because this is at least a little bit more in my area. But, you know, Abel's claim is based on the employer's willful conduct. She does not identify a single willful act that JonesWorks took to access her accounts, which is important. It can't just be because of her own, as we talked about, negligence in connecting and linking her private data and then failing to disconnect it. This is because the amended counterclaims do not allege any. As in Sunbelt Rentals, even if any messages appeared on the JonesWorks iPhone, they did so as a result of Abel's act of syncing the phone to her accounts, not to any intentional act by JonesWorks. I was thinking about this. Now I'm going to go off script, so we'll see how this goes. I was thinking about this because one of the things that I talked about, like I think last week, about her saying, oh, email this on, do you have a private email or a Wayfarer email that Melissa Nathan says to her, was kind of this acceptance of she knew the separation between work and personal. There's these messages that are in here, and I don't remember where they are. I mean, they've got to be after the 21st. But there are messages that I've seen in here, and I guess I don't know where they are, where it says like Jen Abel new number, like don't old number don't use. I'm sure you know what I'm talking about because you've seen them, but I don't know where they are in his complaint anymore. But they've used them a lot in there, and I think that in itself kind of undermines her whole argument here that everything was tied to her phone number and she had access to everything, because a lot of those group messages, they had kicked out Jennifer Abel old number. Yeah, I don't think I'm going to be able to find him, unfortunately. I'm sure you know what I'm talking about. Jennifer Abel old number out of the group chats and included Jennifer Abel new number in there. So this idea that she was intercepting every messages isn't true, because Abel had taken actions to make sure that her old account wasn't getting those messages. She was just getting other stuff that she still hadn't done. So yeah, I think like that also kind of hurts her claim here. But again, it's not in these motions to dismiss or anything, and I don't think they can bring it in. But if this does progress, that is definitely something they're going to bring up. Our scientist says, yeah, I remember seeing them in the OG New York Times lawsuit. Me too. Let's just quickly take a little minute and see if we can see him. If you see him, shout. But yeah, there's like it's in there somewhere. Let's see if we can see it. So if you spot it, shout stop. It's their conversation with Vituscka, TMZ. Oh, I missed that interaction as well when I did the whole Oliver touch points last week. There's the 13th. So yep. So there's that one. Her conversation with TMZ about the Poke Bowl. Leslie Sloan, Blake Lively. Let's keep going. See if we can see it. Because I know I'm not crazy. No, Justin Baldoni and Nathan. Oh, well, it looks like I'm not going to be able to find it. Well, you'll just have to take my word for it. I will find it for next week. That's going to bug me. Usually I know this stuff like off the top of my head. But yeah, I will find it for next week, I guess. Oh no, right here. Right here. It says Jen Abel old number, so they'd already marked it. There's Jen Abel new number somewhere in these as well. Well, there's like one message where I see it's like Jen Abel old number and then Jen Abel new number. But yeah, so I mean, they knew not to have that in the chat anymore or get rid of it. So I will have to find that screenshot. I'm actually surprised they greenlit the whole thing after Jones took phone, which blows my mind. They greenlit it before, though, I think is the problem. They greenlit it August the 7th. But yes, the fact that they continued past having turned the phone over is crazy to me. But it's also, again, like I talked about, I don't know if it was last week or the week before, it's strange to me that knowing you are going in to be dismissed, you did not clean your phone beforehand. Because I have been in those situations, knowing that that I was going to be let go or something like that, and as soon as you see that HR meeting pop up on your calendar, yeah, just go and make sure. Not because you've done anything wrong, but like some of the personal or private pictures that are on maybe a work device or something, you clean up. Yeah, I mean seems like obvious stuff to me. I'm sure it is to everybody else, but I don't know why it wasn't to Jennifer Abel, especially given that she's in PR and having these conversations that she definitely wouldn't want everybody to see. And that's just part of PR, right? Doing stuff on background and stuff like that. So I don't know. She talked about that. Yeah, so again, as in Sunbelt Rentals, even if messages appeared, the data was a result of Abel's act of syncing the phone to her accounts, not by an intentional act by JonesWorks. So again, that kind of doesn't work for her. Again, talking about the other case you cited, and I think I talked a little bit of this. I don't think I talked about the Sunbelt Rentals case, but in that one, the defendant configured an iPhone to access a Microsoft Exchange server hosting the plaintiff's email without their permission, and the logs show the defendant's secret iPhone retrieving and deleting messages. Again, JonesWorks didn't do any of that and didn't put any kind of intercept in there, didn't change any of the device or anything. Again, her claiming a breach of using the SCA, it can in theory apply to trespass into client accounts, but this is wrong for two reasons. Despite Abel's argument that she alleges JonesWorks accessed her communication stored on cloud-based servers owned by Apple and Google, her actual claim is not tied to such allegations. Instead, her original claim was just that JonesWorks had accessed and obtained Abel's data. And again, I think this is another kind of sign that her claims aren't really that strong, that they continue to morph even in the motions to dismiss. Ooh, excuse me. And again, if they were true, they would be consistent. And she keeps trying to duck and dive and dodge and weave with her claims. Second, none of Abel's cases supported by her argument that boldly pleading Abel's data was intentionally accessed and obtained by JonesWorks is sufficient to plead an SCA or other claim. They argue that JonesWorks monitor text messages in real time contemporaneously with their transmission are sufficient to constitute an interception, but that is also wrong, as we've talked about that. Interception is limited only to acquisition during the flight, that is, before the communications arrive in their destinations. And the problem with her phone is her phone was the destination. So JonesWorks having access to the phone doesn't count for wiretapping. Abel alleges no such thing, instead alleging that Jones was viewing the messages in her accounts, not while they were in flight to those accounts. Again, it's pretty defeating for it. We talked about this case, Zaratizian, where, again, the defendant used an auto-forwarding feature to cause the email server to forward all emails to her account, which not the same as this case. That is, the defendant was intercepting the communications and diverting them to himself before they arrived at the plaintiff. And that the court dismissed a wiretap claim because the plaintiff failed to allege an actual interception. And I also talked about that wiretapping claim was also dismissed in that case as well. Because they said, yes, well, they were getting them, they weren't, it wasn't an interception, I think, or one of the ways. But yes, we talked about this a couple of weeks ago when we did the motion to dismiss. So it's nice to see that everything I said back then is coming up in the actual motions that the lawyers are putting out there. So I gotta say, I'm continuing to feel pretty good about this commentary that we're adding on here. Oh, I think I missed. No, yeah, we talked about that she accessed her data, not the data in the clouds, the auto forwarding, and then they come in to talk again about. I think it was this. I think it was this piece. Can't see where I'm seeing changed. Abel argues the alleged lack of JonesWorks policies, this was it, permitted her to have a reasonable expectation in privacy in the iPhone owned by her employer, that because she was using it for personal use and she didn't have a separate personal device, that her employer should have expected her to mix company work stuff and personal stuff. Even if it's true, which it's not, Abel's voluntary provision of her passcode to JonesWorks at the time of her termination nullifies such an exception from that moment forward. That is, for the entire period during which she alleges JonesWorks was invading her privacy. Despite her vague allegations that JonesWorks somehow created a misleading and damaging impression of Abel's involvement in the smear campaign, she nowhere alleges or argues how that impression was false or what JonesWorks did to create it. Abel instead tried to rewrite his claim to now allege that JonesWorks manipulated, altered, and selectively disclosed her private communications instead of creating a misleading and damaging impression. Now she's manipulating her communications. But again, she cannot amend her amended counterclaims in her brief. So again, it's another attempt at her to kind of clean up some of her claims. In any event, the argument directly contradicts Abel's own allegations that JonesWorks supposedly turned over the entire contents of her phone indiscriminately, which again, she's also argued. So it can't be that she is intercepting all of this data, manipulating it and selecting what pieces to, and then also that she just turned over the entire contents of the phone. One of those is true. They can't both be. They go on to talk about the phone number was voluntarily transferred and talk again about how phone numbers are not seen as property, so her conversion claim fails. Again, talking about her emotional distress, and they kind of go deeper into, look, there needs to be the actual claim for this, talking about other cases where they actually pled out significant weight loss and cessation of menstruation, which none of which Abel's really kind of puts in her case either. It doesn't say. And then again, they argue that she shouldn't be allowed to amend her pleading yet again because it's completely broken, and that's it. So that's really it for the JonesWorks case, and so we're fully done. And so I think we're just waiting on decisions now. Let's see what we got. Carla says, it's clear to me that I support Blake, but most content creators support Baldoni. And they're supposed to be intelligent. At least they're not going after the judge if Blake Lively wins. Are they accepting? Oh gosh, no. I don't know if you are at all keeping an eye on what is happening, but they have already gone after Lyman for connections. There was a big conspiracy about the fact that Judge Lyman was a heavy investor in companies connected to Ryan Reynolds. And I think like it was because he had some either 401k or some other form of financial instrument that bundled a bunch of companies together, and it was stuff like Google and things like that, and Disney that, like, yeah, like everybody has that. But they were using that as an example of him having these illicit connections to Ryan Reynolds. So no, they've already kind of gone after Judge Lyman's impartiality, but obviously it's something that Bryan Freedman and his team have to be very, very, very careful about and cannot kind of be seen to boost or acknowledge, because that could be very bad for them. Alsanti says, Abel changing her claims against Jones again must be a day ending in with Y. Yep. I agree with everything I just heard regarding Blake and this being part of a bigger issue that she's trying to expose. This is actually changing the story because people accuse Blake of doing all that all the time, but Blake has been very, very consistent. She's been very consistent, mostly quiet, but yeah, and I think that's a big part of this. I remember seeing him in the OG New York. I think we talked about that. At the very least, change your iCloud password after you've been dismissed as all scientists. Yeah, and I think what's interesting to me is, like, I'm going through this now. I have a Mac, and I'm tying this through. I created a separate work iCloud account. I don't understand why you wouldn't do that. Abel talked about everyone and in the process supplied all the damning information, says Belmoon. Yeah, it was very nice of her to put it in. And I think to me, my favorite is still the conversation with Melissa Nathan and Jennifer Abel, where she's like, look, we can't write this down. Could you imagine how bad this would be if somebody saw this, if this document got into the wrong hands? And it's like, and I think I talked about that like very early on in one of my TikToks. Like, the first rule is, if you're saying, hey, I cannot write down what we're about to do, because if somebody saw what we were, like, if that got hold of that message, it would be very bad for us. Maybe rethink the thing you're about to do, possibly. like if you can't write it down, it's probably a sign to just, go have a cup of tea and do something else. Can't believe she signed over her high school phone number set to junk file. Yeah, and I don't understand. Again, and you said that she was pulling six figures. Yeah, and I mean, like, they talk about how she didn't have the money and she was poor and all this stuff. Like, you can get a Mint Mobile, right? little plug for them or whatever. You can get a cheap phone to just do your personal stuff on. And again, you're not going to be doing a lot of it because most of it's going to be on your work phone. So I don't know. All right, Jed Wallace talked about wanting to go through this. There's not a huge ton of this to go through. This is the response This is the motion to dismiss from Blake Lively against Jed Wallace's amended complaint, which, if you remember, was hilarious because now he's arguing defamation because Blake Lively didn't respond to a protester waving a sign saying justice for Justin and that Blake lied, right? And that Blake not acknowledging that protester and not apologizing for lying was her continuing to defame Jed Wallace, a man who was never mentioned. I don't know, but that's his claim. So anyway, this is her response to it. There's not a huge amount that I want to go into in here, but she carries on in the introduction. This lawsuit does not belong in this court or any court. It's not designed to litigate against any cognizable claim of defamation. It's the latest in a far-reaching attempt to muzzle a woman for speaking out about sexual harassment. Foreshadowing, because that's going to be the second half of what we're going to talk about tonight. Not satisfied with their stealth social media retaliation campaign for reporting on the harassment and misconduct that Lively and others endured on the set of It Ends With Us, now the plaintiffs and their funders, dun dun dun, seek retribution by hauling into court simultaneously in jurisdictions nearly 2,000 miles apart. She brings up the point of, again, the text messages due largely to Jed and his team's efforts to shift the narrative towards shining a light on Miss Lively and her husband. I thought, did I not put this in here? Oh, yeah. Pause on that. We'll come back to Jed and his team. And then goes on to say, okay, so now, for the first time in amendment, plaintiffs now claim, based solely on information and belief, that they were also defamed by unidentified and unspecified statements that happened to occur in Texas, one of which allegedly occurred months before Wallace or Street were even approached by their clients or their funders, referring to Buck Bonanza, because he brought up the whole Buck Bonanza event, and it's like, that was before you were even hired, so how can you have been defamed at that place and that time? Time travel. It's another one of her skills, apparently. That's such a crazy argument. I can't speak for Lyman Hansela, but I think a pretty reasonable person, and I would throw that right out of consideration. Yeah. Another one of the newly purported statements in Texas isn't even a statement at all. Astonishingly, plaintiffs now claim that Lively's silently defamed them by choosing not to respond when confronted with an individual who called her a liar while declaring justice for Justin. Plaintiffs' claim is meritless and fails as a matter of law and requires dismissal for multiple independently fatal reasons. And then she goes into those. We know the background at this point. We are all familiar with the story. And again, we just talked about this. We can't write it down to him. We can't write, we will destroy, we'll go do this. Imagine if a document saying all the things he wants in the ends up in the wrong hands. So good. Lively has so many skills like mind reading and time travel. I might just have to become a fan. She's very talented. Again, though, her main skill is cupcakes. They're incredible. And I'm just saying, if somebody wants to pay me in Blake Lively cupcakes, I will take Blake Lively cupcakes. I am going to keep repeating this until it gets to the right people. Until those cupcakes show up. All right. So yeah, so we got all of this. We know this whole story. I'm going to skip through it. We're just going to get to the claims. Okay. First to root file rule demands dismissal. I think we've been through this, again, this argument that, look, she originally named him on the CRD complaint. They moved it to New York District Court, Federal Court, because, they wanted, instead of having to do a case in New York, a case in California, Bryan Freedman in his in the hearing that they had said, we just want to consolidate this all into one case in one court. So that's why it got moved up into federal court. I think that's in here somewhere. So then they talk about, this Rule 202 petition. I missed the page 21. Let me go back to that. Did I lose my page? Yeah, okay, never mind. I did lose the page. So, you know, again, talking about the fact that, yeah, this is it, where he talked about um, Freedman had wanted to litigate everything in Southern District of New York and combine everything. For the purposes of judicial economy, petitioner is voluntarily flying this non-suit without prejudice to move it to the federal level, and so it would just be one case in one court rather than multiple cases. As of that date, they talk about that Lively had been unable to serve Wallace when they moved it and consolidated it. Wallace had called it remarkable that Lively had non-suited the Rule 202 petition. This is the pre-trial deposition that she filed in Texas to get his information, then non-suited it and said, without waiting for the Texas judge to rule and without taking his deposition, which ignores the fact that they misrepresented it and they avoided service, either prevented a hearing or deposition from ever being scheduled. The real reason she non-suited the deposition was because they could not serve Wallace because he kept trying to avoid service. It wasn't because she no longer wanted to pursue it or whatever, which is why he then ended up getting named on the federal case. And they said in that same hearing, which was back in February, oh, there it is, I think it's February the 4th, that they were going to add additional names to the case, referring to Jed Wallace. So again, so she's arguing, look, this was the first case to be filed, not this one in Texas. Arguing again that Texas isn't the proper venue, which I don't know why you gotta hate on Texas. I mean, I do know why you gotta hate on Texas. There are plenty of reasons to hate on Texas. And then going on to argue that, you know, he's saying, look, it's the venue's Texas because her statements were directed at Texas, targeting Texas residents and published in Texas. Because Lively could foresee that the CRD complaint would be republished in Texas. But even if there were any legal relevance to the claim that the CRD was 100% directed in Texas, the court should reject it as inconsistent with their own pleading that it wasn't published in Texas, it was published in California, which they know and have argued. 27, that was this. Despite, where's despite? Sorry, I'm talking about my own notes in here. You're looking across. Okay. Her non-suiting the deposition. Despite plaintiffs labeling the Rule 202 petition the Texas lawsuit, courts in Texas have held that the Rule 202 petition is not an original action. It's not a lawsuit. So he's trying to say, well, she started this by filing this 202 deposition in Texas. So clearly she was inviting legal action in Texas. She's making the point back that no, just because we asked for a pre-trial deposition does not mean that it then that it's then a interest in Texas for pursuing court venue. Gosh, I don't know. I'm stringing words together here. You understand what I mean. Because it merely authorizes taking of a deposition to investigate a potential claim or suit. Nor does filing a Rule 202 petition demonstrate extensive litigation on the merits because it's not a legal claim on the merits at all. And if it were, the filing and non-suit prior to service do not qualify as having litigated extensively, which is what is needed to meet that claim. This Calder statement, I can't remember what, I looked up Calder and what it was about and I've forgotten now. So I apologize. Calder statement. So she goes on to say, look, he's alleged that it needs to be Texas because of the CRD complaint was aimed at Texas, where both plaintiffs, Jed Wallace and JonesWorks, reside and undoubtedly cause harm because of 203 paragraphs in the CRD complaint. Plaintiffs, and they talk here that in order to meet the criteria, this was what I was looking at, plaintiffs must but cannot show that the plaintiff's activities in Texas or the state itself are the focus of the subject matter of the CRD complaint, and the CRD complaint relied on sources located in Texas to provide new and substantial disclosures. Plaintiffs don't even attempt to meet the second requirement because there were no sources located in Texas involved in the CRD complaint, and so they should reject the application of Calder on the fact of that alone. The focal point of the attached CRD complaint is California. Lively filed it with a California administrative agency based on violations of California law by her California employers and their co-conspirators, all of whom had direct connections to California, including both the plaintiffs. Wallace has submitted a sworn declaration in the New York litigation attesting that he understood his work was directed exclusively to California. And they bring up the affidavit that he had signed in the Lively case where he said, I didn't do any of this. I don't have a team. I thought everything I was doing in California. And they quote him here, putting up, I was providing feedback to Nathan, who I understood to be in California. I only considered the impact of my work to be in California. The goal of my work was to inform her and a team who I anticipated would be in California. And I thought of her work as for Wayfarer Studios, which I knew and know to be based in California. In other words, I thought I was doing business and providing my services to individuals in California. So again, it's pretty damning for him now to try and argue for Texas, especially the other part in here that we've talked about before, him changing where his company is registered from California to Texas after the deposition and the lawsuit was filed. So fun. Milady says, I'm not a fan of sweets, but I would eat anything she bakes. Yes, agreed. They look really good. Chen Pom says, you're killing me. I have the dirtiest comment. Must not say. I'm sorry. I should totally get credit for my amazing self-control, I think. Well, congratulations. I appreciate you for not taming chat. Thank you. Yeah, so I don't remember there was much else in here. Yeah, doesn't really file state a claim for defamation. Doesn't again specify any statement at all. Most of it's just the CRD complaint. Again, the statements in the CRD complaint are privileged under litigation privilege. So yeah, and then plaintiff's theory that the challenge statements in particular in the CRD complete as a whole defame the plaintiffs because they did not engage in retaliation or create, seed, or promote content on social media, or were not retained by tag, did not convey a defamatory meaning. Those allegedly defamatory statements cannot support a claim because they are not more damaging to the plaintiff's reputation in the minds of the average person than the following pleaded admissions. So they again take this idea of the same as we had with the Ryan Reynolds response, that I can't defame you more than you've already defamed yourself, right? So, Wallace says, look, I was the owner of Street Relations. Street's a crisis mitigation firm that clients engage when they feel unjustly attacked, extorted, doxxed, swatted, scammed, or needing help. Lively reported sexual harassment that had taken place on the set of the film. Tag approached the plaintiffs to assist it in social digital mitigation and remediation regarding Wayfarer Studios. Plaintiffs agreed and began to perform work 2 days later on August 9th, including by monitoring social media regarding the film, and plaintiffs performed a job for Tag, Wayfarer, and Baldoni, providing advice regarding the public reaction to the film. Whatever disagreement plaintiffs may have with the minutiae about the type of work they've performed, whether they would characterize it as retaliation or who ultimately paid them, does not change their own admission that Tag approached plaintiffs in August to assist Wayfarer in social digital mitigation and remediation in connection with Miss Lively's claims of sexual harassment. Like, this is what they admit to. And I think, again, like, this is why this is such a problem for Baldoni. And we'll get into this a little later. Like, this is what they admit to. Now, the only real piece that they really haggle over is whether Lively was right to make those claims of sexual harassment, whether she truly believed them. And they flip-flop, arguing that she did truly believe them and she thinks she's in the right, but also they're all completely false and made up. But she did repeatedly make them, those claims again and again and again while filming, which, if they were made up, you would think that they would just suddenly appear one day. They wouldn't have been planted on different days during filming and then grouped up together to build up this list that, she came back to work on June 1st to give them. That feels like that's what happened. I don't know. I don't know how you get to, she made up the claims of harassment by repeatedly making different complaints on different days about different things and feeling unsafe, and then grouping them together and saying, you've done nothing to address this. The mental gymnastics, I don't know. I don't get to how you get to, therefore she made it all up. Anyway, So yeah, as far as whether the plaintiffs were retained by TAG or paid by someone else, perhaps Sarowitz, does not negate plaintiff's admission that they were retained to perform work in connection with Lively's claims of sexual harassment. Moreover, the question of who retained them is not capable of a defamatory meaning. So then they get on to the silence. The dearth of factual allegations about the information and belief statements defeats plaintiff's burden to plausibly demonstrate the existence of defamatory statements. Plaintiff's theory with respect to South by Southwest silence is that Lively conveyed a defamatory implication by choosing not to respond to an individual telling her Blake lies and justice for Baldoni. In other words, plaintiffs perversely seek to punish Lively for showing restraint by saying nothing about them at all. Craziest defamation claim ever. You defamed me by not saying anything about me. Such a claim fails as a matter of law because silence does not constitute a defamatory statement. Should not need pointing out, but apparently it does. Anyway, so that is pretty much it for her response to that. What I said was, hold on Jed on this team. So one of the things that comes up a lot, right, about Jed is this idea of, well, you know, Jed, let me just find this. Jed signed this affidavit, right, where he says he didn't have a team. So he's not going to sign an affidavit under threat of perjury and lie, is he? And I think the thing to me is the number of times that Jed and his team are referred to in this. But before we get into this, there's one other, like, we're going to rabbit hole from the rabbit hole, if you will indulge me. Because one of the other things that gets brought up is I bring up a lot this email where they green light the social media, the combat plan, as they call it. And I bring up this email, right, where Katie's talking to them and saying, or, you know, Abel's talking to Katie. I think it's Abel, or is it Heath? Yeah, it's from Abel to Heath, Melissa, and everybody. And she says, thanks, Katie, just for clarity so we understand. Does this cover your initial fee, plus what we discussed in terms of social media mitigation and proactive fan posting to counter the narrative? Or is this in addition to the $15K that we already agreed upon for TAG and does not include what we discussed with Melissa Nathan earlier regarding social manipulation from the separate team based in Hawaii? In short, is the total fee incurred by Wayfair a $30K, or is more required to ensure we're properly, and it cuts off, but that looks like it's going to be protected. And I've seen people on the Baldoni side talk about this and say, aha, see, this proves they didn't enact the combat plan, because they're saying it doesn't include social manipulation from the separate team based in Hawaii. They never greenlit that. That was never part of it. So if you'll indulge me jumping into a rabbit hole, because I still feel tied to my roots of helping to explain and unpack misinformation. So I definitely want to kind of deal with this because I've seen this. So I want to go back through this, and I want to call out that there's actually 3 separate fees being discussed here. So in this message, he says, thanks, Katie, or she says, thanks, Katie, just for clarity, so we understand, does this cover your initial fee, right? So there's initial fee, Katie's fee, whether that's for TAG's digital team, whether it's for something else, don't necessarily know, but we're going to call it Katie's fee. Plus what we discussed in terms of social media mitigation and proactive fan posting to counter the narrative. Or is the money that you're talking about in addition to the 15 grand previously agreed upon fee for TAG? So we know that they've already agreed they're paying for TAG and Melissa Nathan services, and that is $15,000. And does not include what we discussed with Melissa Nathan earlier regarding social manipulation from the team in Hawaii. In short, is the total fee incurred by Wayfair $30K, or is there more required to ensure that we were properly protected? So he's discussing the three fees, say that 3 times fast, the 3 fees. The total is 30 grand, right? So does this cover your initial fee plus what we discussed, or is it in addition to? So we don't know what Katie's fee is. We're saying it's in addition to what we've already agreed. He's saying there's 15 grand for TAG and some fee for the social media team, and the total is 30K. So we know from math then that the Hawaii team must also be 15K. And so he's asking, is Katie's fee in addition to the 15K we previously cleared about, does not include what we talked about with Melissa and Nathan regarding social media manipulation. In short, is the total fee 30K, or is there more that we're paying to you? So this is actually discussing the fact that, well, they are greenlighting all three services: Tag, the Hawaii team, and whatever Katie's team's doing, which I think is probably just a digital team, maybe, I don't know. But the ultimate takeaway here is there are three fees, and Abel is trying to ask, hey, is your fee covered by the other two fees, or is it in addition to those two fees? Is it 30K or is it more than? Easy enough, right? Also, if you believe Jed, that's how it's not fraud to get paid 15 grand for nothing. I am still stuck on this. That Justin Baldoni was paying a publicist $25,000 a month to do publicity for him during the biggest movie event his studio has ever done. Nobody was watching social media, if you believe them. He also paid, as we see here, at least $15,000 for Melissa and Nathan's services every month for crisis PR during the launch of the biggest movie his studio's ever released, and while he fears that sexual harassment allegations are going to come out against him. They were also not monitoring social media. They had to hire a third team, paying them at least $15,000 a month, possibly more, just to read Reddit for one client. That's what we're supposed to believe. It's crazy. But also, if it's true, I want that job. I think we talked about that before. I want Jed's job. I want 15 grand to read Reddit every month looking for Justin Baldoni posts. It's insane. It's very clearly a lot more than just monitoring social media. So yeah. Or if it's not, I mean, I can do it for half the money. I can find somebody to monitor social media for you for a lot less per month, and I'll just pocket the difference. That works too. So what I want to do, so having covered that, I do want to just go into all of this stuff, right? So we know that there's this Hawaii team that they're talking about hiring, and what the fee is for it. The next day, of course, they send out the email and say, hey, Tag team, is this something you can bring them up to speed when talking to Jed Wallace? You can see the email is to Jed Wallace. They've greenlit it. They want to bring them, plural, up to speed. So if Jed's saying it's just him and there was no team, who is the them referring to? Later on, what we got, 228, later on, they, again, is another message on them, between them, talking about the narrative that was shifting online to point the finger at Ryan. We've flagged to Jed and his team as well. Now, again, remember, Baldoni, Wayfarer, all the rest of them have argued that all of these text messages are accurate. They're out of context. I don't know what other context Jed and his team is, other than Jed and the team that Jed is responsible for. Interesting to see what they go with for that. So a little later, we get another one. You know, we're crushing it on Reddit that we know about from Jed. We are crushing it. I guess that could be, you know, more likely to be the team generally. Wayfarer and Nathan, not necessarily saying that it's about my team is crushing it, but more us, go team, all of us are crushing it. A little further on, on the following day, on August the 10th, a member of the team advised them that they had started to see a shift on social due largely to Jed and his team's efforts. And this is one that, you know, yes, it comes from Lively's complaint, but again, Baldoni has admitted that that all of these are legit and are accurate. Well, I guess I should look for just August 10th. It's in here somewhere. Yeah, right there. We'll continue to keep an eye out said pieces as needed, but so far it's been steady coverage. We've also started to see a shift on social due largely to Jed and his team's efforts to shift the narrative towards shining a spotlight on Blake and Ryan. Again, I'll continue to send links and screenshots, but want to send an update in the meantime. That Baldoni admits they included in there, but then, oh no, they included all these other text messages that say, thanks, Kate. We are seeing the same thing. Thanks, Kate. I'd like to have a quick Zoom today if we can all arrange without Justin. Is that possible for all? I can join, just running around, so I might not be on camera, but just let me know. Happy to jump on, likely off camera. No one needs to see this today. Would 5 p.m. call work? It also circulate a dial in if that's easier for us all via Zoom. Should be fine on my end. Doesn't change the context. That's still Jed and his team, just so we're clear. Still Jed and his team. 251 was the next one. Another text message from them. On August 10th, Abel sent TikTok post of Mr. Baldoni and Miss Lively appearing to laugh together and wrote, would be great for the digital team to boost in any way possible. 253, the team discussed ways to use the digital team to amplify positive stories about Baldoni. We don't know who this digital team is. I'm assuming it's Jed and his team. 256, they talk about the hotel room. Let's chat to Jed on this as well. Again, he's supposedly just monitoring. That whole story has disappeared completely. That video has disappeared completely. Scrubbed from the internet. Don't know where her account is, don't know where her video is. So whatever the Wayfarer did, it was not just monitoring. They somehow either pressured, reported, got it taken down, cajoled, influenced, reached out to this person, in some way got them to remove this from the internet. So he's not just watching. 257, Baldoni responded on the same thread about random posts defending me by people who are private with no followers. Can you please confirm we're not, doing any of this bots? Melissa Nathan says, I fully confirm we do not have bots. This is also not what we do. Bots look fake to anyone. So we do something that's not bots, which doesn't, again, sound like passive monitoring. The other team is doing something very specific in terms of what they do. I know Jamie and Jed connected on this. Again, so there's another team that is not TAG doing something that Jed is able to educate Jamie about. Any digital team these days is far more intelligent to use something so obvious. So they're using something that is like bots. There is a digital team that is doing it. Jed knows what it is about and told Jamie about it. But again, he's just monitoring social media, guys. He signed an affidavit doing it, and he wouldn't open himself to perjury now, would he? And I think that was it. There's one more. 260. In a response to a post, Abel said, I'm assuming this is not true in the slightest. Either way, we flagged to Jed and his team for more serious action on the social side. More serious action on the social side could, I guess, very broadly still mean monitoring, but it is very clear that they still say Jed and his team. So this idea that he signed an affidavit saying he didn't have a team and he wouldn't lie and perjure himself, by Wayfarer's own admission, he has. They understood him to have a team and represented himself to have a team, and that they were working with Jed and his team. Him turning around and saying, oh, I didn't actually have one. Yeah, I don't think it means anything. I really don't think it means anything. Junk Farm says, I think it's the same as team versus associate versus employee. It's semantics. It's a troll farm. Not that do we really care if the bot is a person or something else, or less believable? It's still a drone steering conversations. Agreed. And I think that's it's important in a legal sense, obviously, right? Because it gives you that legal room to maneuver. And well, they said we had bots and we don't have bots and blah blah blah, right? Understood that, right? And let the lawyers figure that out when this goes to trial and do the rest of it. For us normal people, right, who have a conversation, who are not freaking Jordan Peterson, right? Like, what do you mean by bots? What do you mean by smear campaign? Like, you're not kind of doing this endless, like, you need to closely define your words because I'm going to argue and find room to dismiss you by arguing over definitions. If you're not that person, saying, oh, you created a smear campaign and you use bots to influence social media, and you're like, well, firstly, it was not a smear campaign. It was a targeted, well-executed, influence campaign to shift social media sentiment, by closely boosting certain posts and trying to, bury other posts. And we didn't actually, I don't care about the semantics, right? You were deliberately trying to boost positive information about your client while burying your accuser under a wave of negative publicity, right? Like, it doesn't matter how it was executed, it was intentional, it was deliberate, this is what you were doing. How we get there and the wording that we use to get there, I don't necessarily care. Yeah, I don't remember what that was. I think machine. Yes, I think they called it like a smear machine, I think. Yeah, you're right. More or less believable is what I meant. Yeah. I can't believe that the crooked New York Times published the thanks Katie note that proves she's innocent. Milady says, I agree, because it's a lawyer's job to argue semantics and it's a judge and jury's job to figure out what they really mean. In my personal opinion, we'll still take the law into account, we'll also not let people off on a technicality. Yeah, exactly. Scientist says the excluded messages are just so all throughout his thing where he's like, oh, they didn't include these messages. All of them are like, it doesn't change anything. And I think that's might have been my frustrating arguments with people who say, you know, he provided receipts. I've read the receipts. Did you read receipts? Yeah, I've read them. There's not a single message that's changed in context. You know, the emoji doesn't change it. The whole conversation, I think the only conversation that does is the one where they talk about doesn't matter if it's true. I think like that's the only one that like I don't know if it's in here. Yeah, I think it's like August 9th maybe. But I think like that's the only one receipt where they talk about it. And they're like, you know, he's so lucky. I think it's like 10th or something. Yeah, this bit. He doesn't realize how lucky he is right now, and we need to press him on how lucky, the whispering in the ear, the sexual connotations, other members feeling uncomfortable watching it means there's just so much. It doesn't matter if it's not true. I don't think they get that. They think the truth always wins, and no, it doesn't. I think that is like the only bit that kind of changes bits of it. And it's funny because I'm now starting to catch up with Gavel Gavel. And on Gavel Gavel, Thomas said the same thing. It was like, I think this is the only one that like, oh yeah, that actually might change the context of the conversation, right? Because it seems like you're talking about Justin and Jamie, and that they think the truth will prevail, and they don't realize how dirty and messy PR is. And yes, that could be one interpretation of that conversation, as could be others. But it doesn't then exclude, you know, we will destroy her. We can't write it down. Imagine if anybody got a document with everything that he wants in it, right? Like this piece doesn't change any of that. It doesn't change we need to greenlight the social media combat plan. It doesn't change the context of the combat plan itself and things like that. So I think it's fair, like it's good evidence to kind of push that defense. But if that's the only text message you've got, it's pretty bad, especially if you don't have text messages to undo all of the others. It's not enough to have one to say, oh, look, we were nice. Like the one where they say defies credulity, she didn't complain to Sony HR. Well, like, no, what I think defies credulity is them saying Sony HR would have possibly told her anything other than that. Or SAG as well as the other one. Why didn't she complain to SAG? Did SAG literally say, hey, if you can get your own legal representation, go that route? Because what we're going to do is going to make them, we'll write a letter to them to say, please investigate these claims. And if they don't investigate, well, we'll write another strongly worded letter to them. Like, so of course, like she did go through the SAG-AFTRA process because she got her own lawyers, which is exactly what you're supposed to do according to the SAG-AFTRA process. So yeah, and then Sony couldn't intervene, says the Joan Farm. Agreed. And she did complain to them, and Sony told them. And like, again, he admits that in here as well. I think we're going to cover this again a little later. But, you know, he talks about the conversation with the Sony executive, May 29th. Wayfair was made aware that Lively had placed a call to the film's Sony executive to share a few grievances, comments about her wardrobe and her body, about being sexy, showing her a video with nudity. I mean, like, these are textbook sexual harassment. I don't know how it gets any clearer than that. And they're like, yes, she did do these, but if we call them grievances, well, then it's not sexual harassment. Okay. All right. So yeah, that was everything I was going to talk about with Jed and this stuff. So I think next I want to talk about the Amicus briefs. I think everybody that's in chat is going to know what an Amicus is, but I guess we'll do a short little piece. So we got these Amicus briefs. They're not officially on the docket just yet. Yes, they're here. They have asked for permission to file these amicus briefs, and we just need to wait for Lyman's acceptance or rejection of them being on here. This is basically somebody who is an interested party to the case, wanting to offer extra information, saying, hey, in order to help you with this decision, we have inside information, either about this case, about a piece of interest matter around the case, or about the laws in particular that you're looking to rule on. And that is exactly what it is. In fact, we're talking specifically about this California Assembly Bill 933. It's also called Section 47.1 when it was in there into law. And that's what it's in Blake Lively's lawsuit in her motion to dismiss, where she argued that, look, California has this law that basically says, this Section 47.1, which is this Assembly Bill 933, that any communication about sexual harassment is protected from having any sort of retaliatory defamation claim against it. And so whether I did defame Wayfarer or not through doing this, through broadcasting that I was sexually harassed by Justin Baldoni, it automatically fails because me talking specifically about sexual harassment is protected. You cannot then come after me for defamation. And because of that, his suit fails. And when it does fail, when you prevail against an accuser in a sexual harassment case, when you prevail against them in these defamation cases, you are then entitled to have your legal fees paid, and then also punitive fees against them for bringing it, to prevent this kind of retaliation. And we're going to talk about that for a while. So trigger warning, we're going to be talking about sexual harassment and sexual misconduct. We're going to be talking in particular about individual stories and experiences with it. And like I said, that is going to be a deep dive into this, because in response to this, I have seen some absolutely appalling takes about all of this, some misrepresentation of what this law is about, and also the people involved in it. And I want to take time to really deep dive and explain the cases that surround this and clear up a lot of that misinformation. So buckle in, get a drink, because we're going to go for a deep dive into this, and this is going to take a while, and this is probably going to be new information, because I definitely have not yet seen somebody collect all of this stuff together so far. So hopefully this might be a bit of a learning experience. Junk Farm says she was grievance, not harassed. And chat, please keep up the mood, because this is going to get rough. So please try to help me keep this a little lighthearted and pulled out. Anyway, so the first amicus brief is from a collection of advocacy groups. We'll pull it up here. In particular, the Equal Rights Advocates Group, a nonprofit who helped to co-sponsor that legislation, that AB 933. And so obviously they have a vested interest here in seeing how that law is used in this first case, right? I believe this is the first time that it's going to be tested and used. The California Employment Lawyers Association, who were also a co-sponsor of that bill, and the California Women's Law Center, who were strong advocates for that bill. All right, give me a second, bring it up to my notes. So they bring up the point of Blake Lively is anything but an average person. Her experience of being sued for defamation for speaking about sexual harassment, however, is all too common. Hundreds of retaliatory defamation suits have been filed against sexual harassment and assault victims for publicly disclosing their abuse in recent years. Indeed, on its legal hotline, the Amicus Curiae, the people that are filing this, the friends of the court, the equal rights advocates, have heard from its dozens of low and middle income workers, students, and others who were threatened with or forced to defend themselves against such suits in retaliation for speaking about abuse they experienced, or were chilled from speaking out at all for fear they would become targets of such litigation tactics by their abusers. Now, it's important to point out here, these people are filing amicus briefs. They are not filing amicus briefs on behalf of Blake Lively to say that Blake Lively is this amazing person who did no wrong and Baldoni did her dirty and we believe her. That is not what these amicus briefs are about. They are, as they point out here, trying to put this in the perspective of low and middle income people, average Joes, who would be placed in this situation and ensuring that the law provides adequate protections for them. It is the background for which this law was written, drafted, and meant to protect. It is being applied here to an incredibly wealthy and influential and powerful woman. The point being made here is it does not matter that she has those protections. This law should apply to her in the same way it would apply to somebody else. And this is what we should understand, is the way that we apply it to Blake Lively is going to impact how we apply it to all of those people who do not have her power, her influence, and her money. So it's important to understand it in that context. To combat the onslaught of retaliatory defamation suits, they drafted this legislation. The legislation clarified that an individual's communication regarding an incident of sexual assault, harassment, or discrimination they experience is by itself privileged, provided it was made without malice. Now that's going to be an important point later on. It also created a fee-shifting provision and authorized recovery of damages. The intent of AB 933 was to protect survivors from defamation suits filed against them and to deter abusers from filing retaliatory defamation suits, very specific, and to combat the pervasive silencing of survivors that enable sexual harassment and assault to persist at epidemic rates. The action is the first test of this law, and survivors are watching. If the law does not protect a powerful and resourced person such as Lively, then survivors without power or resources, the vast majority, will not risk speaking out about sexual assault or harassment at all. The Me Too movement has taught us that the result of silence is systemic and unchecked abuse at great personal and societal cost. Joke Farm says, what bugs me is Freedman is a Los Angeles attorney and he should know this was going to kick in. He should do, because he has represented survivors of sexual assault and sexual harassment and represented them. So he should know this. Okay, so we get into some of the stats. And if you've seen a lot of my other content, you will be familiar with these sorts of stats, right? According to estimates from the CDC, 54% of women and a third of men in the United States experience some form of sexual violence in their lifetime. And again, it's important to point out that while this is a heavily gendered issue, it is also an issue that affects both men and women, right? While it is true that I think it's something around 97% of women, something in the 90s, will experience sexual harassment in their lifetimes, it is also a large chunk of men as well. So these protections are not merely about quote unquote believe all women, right? Which is how this is often constantly spent. It's got nothing to do with that. It's about providing a space for survivors of sexual harassment and sexual assault to be able to give voice to what happened to them and do so without fear that just making these claims will result in expensive, damaging litigation that will destroy their lives, which is why these retaliation suits are used. In California, more than 8.6 million women have been victims of sexual violence. I'm not going to continue. You can read. Sexual assault has persisted at these epidemic levels for decades. Despite extraordinarily high rates of victimization, most survivors do not report. And again, that is the case for both men and women. They struggle to report. And even the stats that we do have from self-reporting, the National Crime Victimization Study, is probably severely underreported as well, because there are still people who will feel uncomfortable about reporting their assaults, even anonymously on a survey. So it's something to keep in mind that all of the stats we have on this are probably severe underestimations. U.S. Department of Justice estimates that 1 in 5 sexual assaults are reported to police in the workplace. Only an estimated 6 to 13% of sexual harassment victims file a formal complaint with their employer. This speaks to the often, oh, it's false allegations claim, right? Most of the actual sexual harassment that occurs is not reported. It is not some case where we document everything and then these extra claims are people who are finding them to prevent. It is far more likely that it is somebody who has been harassed who doesn't say anything. All right. Abusers weaponize defamation lawsuits. They talk a bit about Retaliatory defamation suits against survivors of sexual assault and harassment have increased at alarming rates, and they provide some statistics for it, talking about threats of defamation lawsuits against sexual assault survivors have risen from 5% of their caseload to the Victim Rights Law Center to almost half of it. So they're a lot more common. And if you think about it, in a place where somebody has more power over you, more privilege, they are likely to also have more money. And so it is very likely that they will then bring a retaliatory lawsuit against you, right? The same people who feel like they can abuse their power to enact sexual harassment and sexual assault are going to feel that way because they have power, privilege, and money. So yes, them then litigating you and using a retaliatory defamation cases against you in lawsuits is going to be part and parcel of them abusing that continued power. Boom. They then go on to talk about DAVO. The retaliatory lawsuits have become a core part of the abuser's playbook to deny the abuse, attack their victim's credibility, and cast themselves as the real victim. A tactic psychologists term DAVO: deny, attack, reverse victim and offender. Under DAVO, the abuser denies or minimizes the harms of any wrongdoing, attacks the victim's credibility, and reverses the victim and offender roles such that an abuser assumes a victimized position and declares the victim to be the true abuser. And if you remember, I talked about this way back at the beginning of the case, right? Where I think it was like Zara1 or I forget the commenter's name, posted a comment talking about, you know, the abused will talk about the abuse, abusers will talk about the character of the abused. And that is exactly what has happened in this lawsuit. I brought it up, like I said, back in January of, you know, this is the textbook way that this thing works, is that you have somebody who is a victim, who makes an accusation, then the person who is the abused then turns around and acts like they're the victim. Oh, I just wish somebody would defend me on my behalf, invoking this outraged mob to then go after the victim for needlessly tearing down a man, for attacking his credibility, for trying to destroy his career, forgetting completely that all of this came about because of his abusive behavior and his inability to recognize that he was making somebody uncomfortable, apologize, or change his behavior to stop that. And that's exactly what we've seen, right? I mean, you look now at where we are in this case. If anybody defends Blake Lively, a bunch of people come out and attack her. If she works with anybody else, you saw the reaction to Another Simple Favor, where it was review bombed. She goes to go do something at a bakery, does a PR event at the bakery gets review bombed. None of that, none of that is normal under a, hey, you know, Justin's really the victim and she's doing this horrible thing to him. Great, target her. But you're also targeting everybody around her because of this triangulation, to where he's such a victim, anybody attacking him, and he's setting it up so that his army of defenders go after you. It is textbook, and I called this out, like I said, back in January. So it's nice to see, again, this being recognized by other advocacy groups and being called out. Now I know that it's going to get ignored, and of course what they do is just again flip it, right? No, he's not Davoing. Blake Lively's Davoing. It's an endless, unfortunate fight that you never seem to make ground with. But Davo works, they say. An experiment showed that third-party observers exposed to Davo are more likely to perceive the perpetrator as less abusive and less responsible, and more likely to see the victim as less credible, more abusive, and more responsible for their own victimization. And again, she deserves everything that's coming to her because she went after Justin. So it's fine that they're attacking every project she's attached to. It's fine that they're attacking every single person who supports her, because they shouldn't have gone after this man, right? You saw it in all of the Instagram comments again, like Brandon Sklenar, oh, you deserve it because you sold your career away to, you know, bow down at Blake Lively and Ryan Reynolds' feet. So you deserve everybody attacking you and shredding your career now. You deserve not to have a career. The moment that that stuff comes out of your lips, you are engaging in that abusive behavior. I don't really have much else to say. They talk more about it, you know, that the UN Special Rapporteur on Violence Against Women called the act of threatening survivors with legal proceedings a form of gender-based violence, again, because of the fact that typically that power lies along a gender dynamic. It's not always the case, but typically it is, and so that's why the reality of it is there is a heavy scale to one way to the other. That is because defamation lawsuit survivors who bear physical and mental health consequences from the underlying incidents are forced to repeatedly relive the trauma through litigation, including court filings, depositions, and court testimony. They're forced to disclose sensitive and potentially embarrassing private information through invasive discovery. And perhaps most troubling, they continue unwanted interaction with their harasser throughout the litigation process, often being forced to testify at a deposition or trial within feet of the person who harmed them. They talk about the cost, which I think again just highlights what they're really aiming for this. The average median income for women in the US was $40,000. One Me Too accuser, defendant in a defamation suit, reported spending $30,000 on her own defense, almost a year's salary, which most people don't have. And certainly don't have like in savings or whatever. Indeed, the financial burden of defending against a defamation lawsuit is one of the main reasons these suits tend to invoke so much fear in survivors. And the Amicus experience low to moderate income workers are simply unable to risk potential financial ruin to speak up about sexual harassment. So then they go to talk about the law itself, right? So the reason they're filing this is to help Lyman understand the intent of the law. So if he makes a decision about how the law applies to Blake Lively, he can do so with a little more background knowledge of like not only what the letter of the law is, but also what the intent of the law was. So they say that AB 933 made two key existing improvements to the law, and I see chats going nuts, so I'm just going to go see. I appreciate you guys sharing your personal stories, man. Sorry. I'm sorry that this is a mark of distinction that so many of you share. But I'm grateful that we are all using it as an experience that we can use to then advocate for other people. Yeah, okay. So they talk about the law and say that it made two improvements. Under California law, it expressly clarified that communications are privileged and thus protected from defamation when they are made by an individual without malice regarding an incident of sexual harassment or discrimination. So the very act of talking about sexual harassment is by itself not malice. And this is the thing I think constantly gets twisted by all of like the people who are still defending Baldoni. Well, you know, she tried to ruin his career. She didn't try to ruin his career. She simply made the allegation that he had conducted sexual harassment. Now, again, that in itself cannot be the bar for malice, because if it is, then any person making any allegation of sexual harassment or assault is also by malice, and this code could never apply. So they're arguing, well, it must be malice because she made it up. But again, we'll get to that in a moment. This idea of, well, it's malice because she invented them. This harassment never exists. It defines communication as factual information related to an incident of sexual assault, harassment, or discrimination experienced by the individual making the communication. It clarified that such communications were protected regardless of whether they were made in an official complaint of abuse or not. So remember, go back to what I talked about with Baldoni's timeline, right? By his own timeline, his conversation with Sony, Miss Lively had told Sony he'd made comments about her appearance, about her being sexy, and that she had been shown a video that included nudity. This by itself triggers that, right? It does not matter whether you think, well, she made it up or whatever. Baldoni admits that both of those events happened. Miss Lively has complained about them, made complaints to Sony. Sony conveyed those complaints to Wayfarer. This already, at this point, based off the factual information that Wayfarer admit to, cements this protection. Now, again, I may be wrong, right? Maybe like when the lawsuit gets decided. But in my mind, right, as a non-lawyer, this is not even a negotiable because of he admits those events occurred. He admits that Miss Blake Lively took them in that interpretation and that she communicated them to other people and communicated them as simply complaints that wanted change in behavior. And immediately afterwards, of course, he says, I want you to know I've been made aware of your concerns and I hear you. They're fully received and adjustments will be made imminently. He doesn't take them as a threat to take control of the movie. He takes them as genuine concerns about his behavior that need change. That just never happens. Sort this out before filing your defamation suit. If it's false, then resolve it through the legal process before enacting a separate act of defamation. Here's the thing. I think, and again, you're getting me not as a lawyer, my lady. So you're getting like discount legal advice that's worth nothing. But I think that's part of the problem, is it's not even a case of that. Because if you file your sexual harassment case and you lose, it's still made in good faith. Losing your sexual harassment case by itself doesn't mean it. I don't think that then allows you to be open to a defamation case afterwards. I think, as this law is, whether it's, you argue that it's possibly broad, protects you from retaliatory defamation cases regardless. You would actually have to have concrete proof. You'd actually have to have some evidence that those allegations were invented, that they were false, not merely enough for it not to survive litigation, right? For you to not prevail in court. So Lively could go all the way to court. The jury could decide, we don't really feel like this was sexual harassment. That wouldn't then open her to a retaliatory defamation case. As I understand things, could be wrong in chat. Let me know, right? If I am, or if you've got a different understanding. But from what I understand as the law is written, it genuinely protects you from making good faith allegations of sexual harassment, even if you don't prevail in court. It also protects you even if you never make any allegations in court. And we're going to get to talking about that later as we dig deeper into this case. But it protects you just for making communications, right? And that's important. So if I just tell somebody, hey, I think Justin Baldoni did these things, I feel uncomfortable, he did this to me or he did that, that's protected. Whether she intended to file a lawsuit or take him to the law, or whether she just wants to tell her friends about it, it's protected. Entirely because the whole goal of this is to just protect survivors from being able to speak this without facing being obliterated in retaliation lawsuits about it. So that, and yeah, the retaliation is illegal even if she lied. I think if she lied and they can prove it though is problematic. But you're right, my lady. A preemptive defamation lawsuit is absolutely weaponizing the legal process, 100%. Second, they award damages, treble damages, attorney fees in part, because again, thinking about that average Joe, if you don't have this provision, you can't bring a lawsuit. And they make this point later, but I'm just trying to get through this a little quicker. The idea being that, if you have to hire a lawyer to do this, knowing that you have to pay for your out-of-pocket, and that even if you win, you are still on the hook for your lawyer's fees, you might not be able to afford that. Now, if you can make the other side pay for your lawyer's fees, you can then hopefully find a lawyer who will take your case on the understanding that, hey, if they win, they will then get their fees and then also these triple damages. So that is a reason for doing it, is that it helps those low and middle income people be able to afford representation and lawyers to be able to defend themselves, because then there's this provision of, hey, this seems like an easy case to win because you've made these allegations, they're in good faith, there's just a blanket denial of retaliation defamation lawsuits. So it should be fairly easy to know that we can win this case, and then I can take this case on reliably, knowing that I'm going to prevail, and then I'm going to get paid. So that is the reason why it's done like that. What do I got? Prevailing. Oh, it was their second point. Yeah. I can't remember why. What I was going to kind of take a pause to point out was a lot of the Baldoni side have said, well, he's not trying to strike down this law. He's just arguing the malice portion of it. He's saying that Lively made these claims with malice, and so that's why this doesn't apply. He's not actually trying to strike down the law, and these advocacy groups are overreacting. So I want to bring up his opposition to motion to dismiss. And on page 23, this is where he's saying that Lively's defamatory statements were made with malice and without a reasonable basis in fact. And he argues here it only applies to communications made without malice. And so those requirements that the communication may be without malice and have a reasonable basis in fact are why Lively's argument falls flat, he argues. He then also includes this footnote. Section 47, which took effect on January the 1st, has not been addressed in a single published or unpublished judicial decision. Thus, the court's treatment of the statute will be a matter of first impression. Section 47.1's mandatory award of treble and punitive damages is in fact unconstitutional and a violation of the First Amendment guarantee of the right of the people. We talked about the Noah-Pennington doctrine before, this antitrust law. It's got nothing to do with sexual harassment cases. He's trying to misapply that doctrine. Whether he's successful, I don't know. But he literally argues in here, it is unconstitutional. I think, where is it? It's further down, 42. So going through here, he says, look, even if the motion is granted, the fees and damages can't be awarded. And he doesn't say it's about this because of malice. He argues here, Section 47.1 cannot be used as a basis for award for damages or fees for the same reason the actual anti-SLAPP statute can't provide it. Application of this law is in conflict with Rule 11 of the Federal Court Rules of Court Procedure, because they say basically, where is it? That sanctions are permissive, whilst under Section 47.1, sanctions are mandatory. Accordingly, Lively cannot be awarded any of the damages or fees because of the issues. They preclude any such award because the statute conflicts with it. Finally, right, so he doesn't just argue that, it's malice. He argues that it's actually in contradiction to the federal rules of civil procedure. And then he argues awarding damages under Section 47.1 would violate the US Constitution because imposing triple damages on unsuccessful defamation plaintiffs would impermissibly burden the exercise of rights protected by the Petition Clause of the First Amendment. So again, he's arguing that no, 47.1 on its very basis, if nothing else, even if she's successful, even if she doesn't have malice, even if I do get my case dismissed, it still shouldn't give her any money, right? Because it's unconstitutional, which is why he summoned these amicus briefs from those advocates who put the law together to go, you wait a minute. So again, they talk about why they drafted the bill to address two distinct problems. The first is preventing abuse discovery. And they talk about part of these retaliatory defamation suits is the abuse of discovery to re-traumatize victims and survivors, right? So again, think about a case where you have not gone to trial, where you are not. Now, this doesn't apply to Blake Lively because she already started this out by suing Justin Baldoni. So there was going to be discovery anyway. They're saying that, look, in these cases with these retaliatory defamation cases, they're often used to use it to get discovery on the person. So think about you just making a communication about sexual harassment, you telling a person about it, you reporting them. That would open you to a retaliatory defamation lawsuit. It does not matter whether you have filed litigation or not. And then they can use that to then go through all of your text messages, all of your conversations to find out, oh, well, who else have you told about this? And in order to just rip apart your private life. And again, very different case that we're talking about with Blake Lively, somebody whose private life is often ripped apart and in the news and all the rest of the stuff, even though there are limits to that. For private citizens, who are not Blake Lively, very, very different and very, very invasive. I mean, it's still incredibly invasive for a public figure, but even more so for a private citizen. So again, coming back to why we all got involved in this case in the first place was to think of that survivor advocacy and to basically say that this case is not really about Blake Lively. It is about every survivor. And yes, there are concerns here where you can go, well, she's a public figure. She did great. We're not talking about her. We're talking about a generic survivor, a generic person who makes claims of sexual harassment. And that should always be what we're thinking about when we come to this case. And that's what the ERA here are trying to remind us of. So they talk about preventing abuse discovery, and then the other is compensating survivors and deterring the filing of abusive retaliatory lawsuits, which we talked about by giving them these fees and assuming that like these are mandatory fees if you fail, that the retaliatory defamation cases instantly fail. They instantly recover any attorney's fees that you need in order to combat them, and they give treble damages, all to prevent them from being placed out in the first place, because they are completely inappropriate in a case where the only issue, the only defamation that has occurred is that you made an allegation of sexual harassment. And that's what's important. And you did so in good faith. You did so fully believing that you were sexually harassed, and you weren't doing it with actual malice. I don't know if they use actual malice or just malice in the legal terms in this. Where are we? Page 23. They go on to then say, look, denying Lively's motion to dismiss would undermine the whole framework of why we have this law in the first place. Should this court deny Lively's motion to dismiss and permit the Baldoni plaintiff's retaliatory lawsuit against her to proceed, it would undermine this carefully crafted framework, not just for Lively, but also for thousands of current and future victims of California who depend on AB 933's protections. They also point out that Baldoni has kind of acknowledged 933 and said, well, look, even if it protects Lively's statements, they argue that both Reynolds and Sloan are agents of Lively, and so she's liable for their statements that they made, even if she would not be liable under AB 933. The ERA, the Amicus argues basically that even if they did, even if Reynolds and Sloan were the ones that made the comments about sexual harassment, because they're her agents and Lively should be responsible, then by the same understanding, AB 933 would also apply to them and would be covering them with privilege because they're agents talking on her behalf. Can't have it both ways. You can't make them agents of her and that their actions she is legally responsible for, but then also not offer those same shields and protections to them. You can't have the risk without the shield, essentially, is what they're trying to argue. Then I'm going to say Lively's a public figure. The lawsuit has captured the attention of the American public. The outcome of this motion will affect the decision-making of other victims of sexual harassment and assault. The Baldoni plaintiffs have already signaled their intent to follow the abuse discovery playbook by invading Lively's personal privacy and disrupting her relationships, as frequently happens with other survivors who speak up. And they bring up what happened, a couple of weeks ago. Indeed, in a seeming gambit to disrupt her friendship with Taylor Swift, they subpoenaed the music star, even though Swift has no connection to workplace harassment and retaliation at issue in this dispute. Whether or not these high visibility abusive tactics work against Lively, they almost certainly will deter survivors from coming forward with allegations of sexual assault and harassment in their own lives, especially when you look at the amount of vitriol and that is placed upon them. Lively, anyone who speaks up for her, anyone who defends her, anyone who works with her, all of that has a chilling effect to everybody else who's seeing this going on. And it's not just her. At the same time all of this was going on, I did the whole story about the allegations about the impractical jokers. And in the same way, the young women who stood up and talked about the harassment and misconduct that they experienced the same kind of harassment, silencing, bullying, shaming, ridicule that we're seeing against Miss Lively. Like, it's not separate. As much as people want to defend and say, well, it's just her, I don't believe, as we're going to see as we continue with this, it's not just her. It's everybody. It's always, and it needs to stop, period. And it's laws like this that help provide those protections. I'm going to take a break for a second and look at check. Now, Natalie says, guaranteed, if she gets it dismissed, the next conspiracy will she knew this law is going into effect, so she crafted this plot knowing that she wouldn't have to prove anything or some BS like that. They're already making those sorts of claims, Natalie, and I'm going to, I think I'm at the end, so I think I can talk about this now. So one of the reactions that I saw to this, right, I think it's important to understand what this law is about and what it's not about. This law is simply about retaliatory lawsuits for defamation, right? And this idea that it's preventing discovery and you digging through that person's life is only in those cases, right? You don't get to, if somebody has not filed a lawsuit against you, go file a retaliatory defamation lawsuit against them for saying, oh, they're accusing me of sexual harassment, and then go dig into their life and get that kind of discovery. But one of the wild takes that I saw about this law was trying to shield an accuser from discovery is completely the wrong approach. This protection only applies to complaints that are free from actual malice and is, in many cases, only going to be proven with discovery. If we start a presumption of guilt or liability for male on female violence, we get on a slippery slope of setting that precedent on other allegations. The system is hard for women. I know this, I've been through it myself. It needs balance reform, not the removal of due process, which is the interpretation of the law the Amicus are trying to argue. The law is neither equality or justice, in my personal opinion. Every piece of this is wrong from top to bottom. So let's take this first paragraph. They talk about the protection only applies to complaints that are made free from actual malice that in many cases only going to be proven in discovery. 100%. But if the complaints are free from actual malice, like in Blake Lively's case, right? You're already going to get discovery because there's a complaint, right? The complaint has been put out there. I'm making a complaint against you for sexual harassment. I'm taking you to court. Both sides are going to have discovery in that case. What this protects is if I'm not going to make a formal complaint, if I'm not going to make a legal case against you, if I simply say, I have experienced inappropriate conduct from this person, you don't get to then file a retaliatory lawsuit against me to then invade my personal life as just retaliation and what I deserve for daring to accuse you, right? If I ever speak that, oh, such and such a body was inappropriate with me, that doesn't give you a right to file a lawsuit against me, invade my private life, force me to spend thousands of dollars to defend myself against defamation. That is what this law protects against. It is not protecting an accuser from discovery, right? If that accuser wants to take you to court, they will have to go through discovery. What it protects that accuser from is not having to have discovery weaponized against them as punishment for making a claim, for making a non-legal claim. It goes to say, if we start with a presumption of guilt or liability, it doesn't start with a presumption of guilt. Again, it doesn't mean then that that person who's making those allegations is telling the truth, right? That person could be full of crap, and if they don't have a lot of evidence or anything to go with it, they might well be. But the big problem with a lot of these cases is it is their word against your word. There are not a ton of other witnesses around, entirely because it's sexual misconduct. Very rarely does somebody say, hey everybody, come around and watch me while I do this to somebody. Entirely because you don't want witnesses to you doing crime, typically. So it is going to be your word against their word. There's not a presumption of guilt. It's just about allowing people that space to be able to make those allegations and to talk about them. You do not have to take them as fact, and it does not then mean that that person is guilty, especially if it does not go through litigation and does not go to trial. And then this whole idea, we get on a slippery slope of setting that precedent on other allegations. This worry then that all men will be accused, right? This is the argument, oh, you can't talk to women anymore. You can't do anything these days. I can tell you now, the only men who make that claim, the only men who have that problem, are the people who are making those kind of behaviors. And I thought it's interesting because I think it's in Lively's amended complaint, right, where they end up talking about that. Baldoni ends up talking about that. There's a thing where he says, like, oh, you know, I can't tell you about this because I can't say anything. And I don't know if I believe that for a second. Just as a point, right? There might be some things where, well, that feels a little much. Is it in here? Yeah, there he is. Dude, I have to tell you something, but I don't want to get cancelled or lose my job. You can't say anything on this set that's more. I'll say this. Oh, actually, let's go look. I'm interested. Did he actually acknowledge that he said that? Do we think? Did he actually say that? Did he actually say that? I don't remember now. Now I want to go look. Okay, he says don't know. He doesn't know. He doesn't know whether the other person said that to Lively. So he doesn't admit or deny really saying that. He says he doesn't have enough information to respond to this. I will say this. This seems a little cartoonish. This seems a little much. This seems a little like this is what I would expect somebody to say. But if that ends up being the case, I will not also be surprised because again, the men who think like this are typically the men who have problems. like, yeah. Um, so yeah, this idea that it sets a slippery slope, I don't get either. Um, and then there's not the removal of due process. Like I don't think you, and it's funny because this person is supposedly a lawyer. You would understand that due process is entirely happening. Even if you remove Baldoni's retaliatory case, he still gets due process in Blake Lively's case against him. He still gets discovery. He still gets to go to trial. He still gets a trial by jury and to defend himself. Like, this is due process. It's often misrepresented that this law basically puts the scale, like the weight on the scale on one side, and that the person being accused doesn't get to defend themselves. And I hear this so often. That, oh, what's he supposed to do? He's not supposed to defend himself. And he's like, no, he's going to defend himself. In Blake Lively's case against him, he will get a chance to defend himself, present evidence, and show that she's not telling the truth, if that's the case, right? He's going to present all these evidence. What this law prevents is what he's doing right now, which is he's brought this completely frivolous claim against her. Doesn't have any defamation specific statements that he can point to. The only ones he has are the predator statements made by Ryan Reynolds, which are nothing to do with Blake Lively or the movie, and just about his contract with WME, maybe, arguing that Ryan made a comment to WME and then months later they terminated his verbal contract, and so therefore those are tied together. And then, he's alleged that Sloan had made some statements, but he can't point to a single one of them or a single article that she ever planted. He doesn't have a single defamatory statement for Blake Lively. So like this is what shouldn't be allowed. And what it is he can bring that case, but it's going to get dismissed because it's so frivolous. And when it gets dismissed, that she would get paid for it, that she would get her legal fees covered for having to deal with this unnecessary frivolous nonsense, and then the triple damages. This is exactly the kind of behavior and action that this law is meant to curtail and protect victims from. And it doesn't matter that it's Blake Lively that is receiving the benefit of that protection. It's there for all victims of sexual harassment who face an abuser who then wants to take them to court and ruin them financially, emotionally, and reputationally for that. So, yeah. All right, we'll get to the second one in a second. I'm going to take some chat for a second. Obi-Wan Kenobi says, this whole thing has been retaliation. It's been solely focused on her personal life, her marriage, her friendships, her parenting, her career, not the allegations. Or the fact that Blake Lively isn't the only person making allegations, right? Like, we have covered this. The Hollywood Reporter article came out and clarified that yes, Jenny Slate supposedly, allegedly, has also made a complaint against them, and that Wayfarer knew what that was, and it was supposedly to do with her apartment, and she's just blowing that out of proportion too. Oh, these crazy women. You got Blake Lively making complaints, but she's blowing it all out of proportion. Well, Jenny Slate, she's also blowing it out of proportion, and supposedly we have at least a third complaint that is still to come out from somebody else. And I'm sure we will be told as well that poor person doesn't know what they're talking about, and they were also blowing it out of proportion. I don't know how many times somebody has to tell you that everybody else is the problem, they're terrible, before we accept that no, like this person's the problem. The entire cast turned against him, right? Colleen Hoover turned against him, right? Like the author of the book, who he's making a lot of money for, also decided that she didn't want anything to do with him. And of course, he's painted this as, well, Blake Lively did all of this. She did all of this against me. Very rarely is that ever the truth, right? I don't know. It seems crazy to me. How about Blake's staff who she pleaded in her protections? Yep. I mean, like, as soon as this goes to trial, and like I've talked about, if that driver or her assistant can corroborate the conversation about, did I always ask for consent? It is over. Master Jinx says hello. Welcome in. Hysterical women, lol. Right? I know, right? It's the meme, right? Women with the coffee, the coffee mug. I mean, like Justin Baldoni has pretty much turned into that friggin' meme. His Turner turned against him. Yeah, his trainer turned against him. His Turner trained against him. Wow. But yeah, that's another good point. From like everybody who worked with him, his own publicist, was calling him out. Like everybody who works with him doesn't seem to have a good reputation with him and understanding. So like, it's interesting to me. It slays me. Junkram says that all the staff. He basically asked all the staff to start watching for HR issues. Yelp. Natalie says the type of misinformation that was going around when she submitted her CRD complaint and they said it to avoid discovery, even though she did it to literally get the right to sue. Oh, I mean, like it will never, never, never not be funny to me that forever enshrined in his New York Times complaint that he brought on here, right, was like that she's not going to sue, and I can't remember where it was, with no intention of suing or whatever. I mean, it says here she firmly was going to go rather than pursue any legitimate grievance. I'm sure there was like there's something very early on in this that says like she never intended to bring it to a legitimate case. There you go. Does not subject it to discovery. It can precede a lawsuit. It's clear that litigation was never her ultimate goal. Like, wow, what a claim! And he put this in here on, what was it, December 31st or whatever, the very same day that she actually filed her complaint in court. Like the moment that they hit send and submitted that to the court, they were wrong. And I don't know how many times Freedman has to be wrong before people again like start to question his ability, because like he was wrong about she's never going to litigate this. He says on the day that she litigates it, there was never a subpoena, and there was a subpoena. Like how many times is this dude gonna just not be able to read the room? It's wild. All right. Gosh, we're already at 2 hours. Oh my goodness. All right. I think that's it. All right, so the next piece I want to talk about, well, I did actually also want to just finish this out by talking about the fact that right at the end of this, well, this was brought on a bunch of different organizations on behalf of like the Equal Rights Advocates, the California Employment Laws Association, the California Women's Law Center. It was, written and signed by Dana Bolger. I didn't know this. I didn't know who Dana Bolger was, so I had to be educated on it. So I appreciate those of you who helped me with that. But Dana herself has been an advocate for victims of sexual harassment and sexual assault. Dana is a founder of Know Your Nine, an advocacy group educating about Title IX protections and wanting to end gender-based violence in education by educating students and university students and school students on Title IX protections that are available, which is that no person in the United States shall be discriminated on or excluded from participation in any education program or ability receiving federal financial assistance based on the basis of sex. And so she's been long part of this advocacy group, done a lot of work on it herself, being a survivor. And so you have another survivor of sexual harassment or sexual assault, should say, presenting this on behalf of advocacy groups, all of them really hammering home that this case is about those protections for sexual harassment. And again, that lively succeeds in her motion to dismiss his defamation claim doesn't mean that he's not able to then sue for other things, right? If he thinks he has a valid extortion claim, he's welcome to sue for that. If he thinks he has a valid claim for, the interference in contract, he's allowed to sue for that. What this is to, dismiss his complaint for defamation and his claims on that. It should be understood that this is very specific. It's not curtailing Baldoni's right to ever sue Blake Lively for damages against him, right? It's about him just trying to say, you defamed me by talking about sexual harassment. It's very limited. Okay, so with that, we go to the other amicus brief that was filed, and it was filed by Elise Darcy. I am going to cover this, but first we're going to go into her story and her background before we cover any of it, because I think it's important. I think there's been a lot of misinformation about her story, as I was talking about, and so I really want to cover it and dig into it. So, Elise's story is basically really the story about a gentleman called Joshua Wright. Professor at George Mason, I believe. Also worked for the government, for the FTC, the Department of Justice, other big law firms and stuff. And basically, there's this article here talking about him, and I think this is where we'll start the story, and we'll kind of go back a little bit, talking about his wife sending him a message that Lindsay says you have a lot of things to tell me, like about other women. But essentially it was revealed to his wife that Joshua was having relationships with a number of other women, which then came out that basically that they were students at George Mason while he was a professor. That this particular girl, Lindsay Edwards, they had started a years-long sexual relationship. When she was a law student, he was a professor at a school. That Wright had helped Edwards join him at the law firm Wilson Sonsini, Goodrich and Rosati. I don't know if I'm saying that correctly, so we're just going to say Wilson. And then continued the affair while she was at the law school. Edwards had gone house hunting with Wright and told friends she looked ahead to marriage, children, and comfortable life together. For more than a decade, Wright had built a multi-million-dollar career protecting Google, Amazon, Facebook, Qualcomm, and other companies from antitrust regulators. So he'd worked as, helping those big companies build their monopolies and protect them from a lot of the antitrust protections that were in the government and regulators that were coming after them to try and stop their giant monopolies. That he was a consultant, a law professor, and then a member of the FTC. He managed to convince his wife to put off the divorce, but the affair with Edwards soured, and then Edwards told a friend that she was prepared to tell Wright's wife everything. I have her number ready to go anytime, Edwards wrote on February 2020, that he thinks he can just get away with all of it. Savage, I love it, replied Angela Landry, a lawyer who a decade earlier had also begun a years-long affair with Wright while taking his law school class at George Mason. I'm going to talk about it, but their relationship ended in 2016. But again, it was another student at George Mason that he had an inappropriate relationship with, that he used his position to get jobs for her and abuse his position and power over her. He's a effing predator, Edwards wrote. So after learning of his infidelity, his wife hired a divorce attorney, kicked him out of the house. Don't necessarily have clarity on it. I think the divorce proceedings began in 2019 and then ended in 2020, but I'm not 100% about that. So, but it's around 2020 that he gets divorced. He also is then forced out of the law firm Wilson Sonsini for lying about having an office romance with Lindsay Edwards. They talk about that it didn't slow his career, that Wilson Sonsini still wanted to keep working with Wright. And while the Justice Department was investigating Google, they told him that he could keep working for them, keep them involved with working for Google. An arrangement, she said, would make him at least as well off, if not better off, than when he was working for Wilson directly. One example might be for you to continue to bill through the firm effectively as an expert and keep 100% of the revenue. Another would be for you to bill Google directly. So even though he was fired from his job and let go because of having an inappropriate office relationship with a young woman who had formerly been a law student while he was a professor, they continued to work with him. It definitely wasn't great for them to have him officially on the books because that would be bit scandalous, but they could still pay him under the table and work with him so that people didn't know. Wright got a consulting contract with Google, and that Google had no knowledge of the reasons that Wright was fired from Wilson Sonsini. Funny how they didn't want to advertise that. But let me say, so yes, in 2020, the Justice Department filed its antitrust lawsuit against Google. Wright's consulting business was thriving. He was working for a number of companies that were in the sights of Google, of the antitrust regulators, including Google, Amazon, Facebook, Qualcomm, Walmart, and also Kirkland and Ellis. It's a large law firm, and that name will come up later. I think that's about it from here. No, so there was an obvious conflict of interest. Wright had a bunch of, he was the director of the university's Antitrust Institute, Research Institute, that had a number of donations from folks like Google and Amazon, who had each donated $1 million to the Global Antitrust Institute, which, you know, he was director of, which at the same time, he was also representing their interests. And then he also ended up on the FTC, where he was then, you know, litigating over them and working with them and kind of working to reduce the FTC's power over like these antitrust kind of lawsuits and against these companies. So they called it out as being like a complete conflict of interest, that he was getting, you know, these companies paying into his research at the university while also like working for their interests and not disclosing that conflict of interest that they were paying for him. I think we'll come back to this. No, let's not. Let's go through this piece. The George Mason University declined to tell the committee how much the companies had contributed. There was another student, and this is where Elise Darcy comes in. Elise Darcy was another student that Joshua Wright had a sexual relationship with, that he had approached and used his power and position as her professor to begin an inappropriate sexual relationship with her that carried on for years, and that he used his influence and power to get her a number of jobs and open doors for her. They talk here about he hosted Elise in January 2019 at a hotel in Florida during a training seminar. Wright initiated the sexual relationship with her when she was a law student. He'd later help her get jobs at Wilson Sonsini, the FTC, and the Justice Department. 4 months after his trip with Darcy, Edwards and Wright were in Lisbon. So the other woman that he was having an inappropriate relationship with that was a former student, organized a week-long training seminar. Wright lectured foreign officials. Edwards posted pictures of her on social media. A Wilson Sonsini associate saw the pictures, alerted Darcy, who believed her affair with Wright was exclusive. You know who's apparently not far away from you, he wrote, Lindsay. Really weird, Wright said, and it was suggesting it was a conspiracy. That's some bullshit. So back in 2019, they started to learn that he was actually having a number of inappropriate relationships with students, and that they were still going on years later, and that they didn't know each other. There was another person who had also reported him, Brandy Wagstaff, a lawyer at the Justice Department. In 2005, Wagstaff had been a first-year law student in Wright's class, so this is 2005. They had an affair the following year, sometimes had sex in his campus office. Looking back, she said, it's just shocking to me that those that shared the office space with him would be clueless. Wagstaff had been an adjunct professor at George Mason for about 6 years when she heard from women on campus that Wright was still having affairs with students. So this would be 2011. In 2017, Wagstaff reported what she had heard to university officials. A campus investigator asked her to provide names. Students told Wagstaff that they did not feel comfortable identifying their classmates to the university authorities, and the matter was dropped. Wagstaff did not file a complaint to the university about her own affair with Wright until late 2020. I feared retribution, she said. He had so much of the power in the school, and again, nothing came of it. In early 2021, Krista Laser, a law professor at Cleveland State University, responded to a job posting at George Mason University's law school. She sent an inquiry to Wright, who was in charge of hiring. Wright said he was free to meet over dinner the next night at the Liberty Tavern, a restaurant near campus, over tapas at a high-top table by the bar. Wright told her the law school might have an opening for her, Laser said. The law school dean always follows his recommendations, she recalled Wright saying. After dinner, Wright walked Laser to the car, she said, and hugged her for an uncomfortably long time. Laser emailed Wright to thank him for that meeting. He replied from his personal email, and she ended up posting it to social media, so I'm going to show that. No, I'm not. I am going to show it, but it's not there. I'm going to show it off of social media for you because it's still up. So this is his response. Remember, he's a professor. At the time, she was also a professor, wanting to come to a job at George Mason's law school that he was a professor at. They'd had dinner to talk it over. She thanked him for the dinner. This is his response. Hope you had a great day. Just about to do a FedSoc panel, but I thought I would check in and say hello. Catching up in May sounds great. I really hope this doesn't come off as overly forward. But I really enjoyed dinner and talking with you and thought maybe you might be interested in making next time a date. Absolutely no worries if you're not interested or the time isn't right or you just don't like guys who do antitrust. Smile emoji. But I thought I would ask. Otherwise, I'd obviously still be thrilled to get together to talk job market catch up. Now, Krista says that she had told him basically, no, I don't want to go on a date. And the moment that she did, basically Wright told her that he didn't have a job for her. And then she complained to the Human Resources Department about Wright's behavior. She said she spoke with a campus investigator for an hour on a call and never heard back. And then at the end of 2021, the school received another complaint about Wright, one that could not be ignored. I'm going to pause there and just read chat for now. Where are we at? The quid pro quo sexual harassment goes on for a long time. Eventually is an harassment talking point. It's coming up a lot with Dorsey. Yes, and we will definitely talk about that at the end. Because Marcy Jinx, it reminds me of a lot of things that I've talked about before. So we're going to carry on through Dorsey's story. But yes, keep that in mind, this idea that, well, you know, he used his position to get sexual favors in order to, you know, give them jobs and help them out and connect their careers. So it's not really harassment. We will definitely be talking about that. I think that's it. Let's see. Poor expatriate, we're going kind of crazy again. Hey, look, no, it's good. I just want to make sure that I'm catching the comments, and if you guys are having fun together, that is all good. The ASMR sexy calls are super weird from Chunk Farm about Baldoni. Yes, they very are. You'd think students saying, yes, that happened, but I don't trust you to tell you who it happened to response would mean something. Yeah, I think it's interesting that then that gets dropped rather than like, oh, that seems like we have a severe problem in that like they're not able to blow the whistle. But again, it comes back to exactly what we're talking about with this law, right? They feared retaliation. They feared a esteemed and powerful law professor who makes a lot of money being able to use that power and influence over them to make their lives miserable should they ever dare to speak out about his behavior. So, I mean, it all ties into exactly this. The fact that Baldoni is following the playbook so closely is insulting. Oh, just wait. Just wait. You're skipping ahead. And yeah, it is so much worse. Let me pull up this one. I didn't do the best notes on this one, so I don't know what I was wanting to read, but this is more of Wright's story. Yeah, so this is where we're going to go to and start talking about Dorsey. So at least Dorsey, he says, in 2010, Wright courted two women he taught in his law class. One was 24-year-old Angela Landry, that we talked about, that Edwards had sent the message to. He had told her he had separated from his wife and that they lived in the same house only for the sake of their children. Wright invited Landry to be one of his research assistants, a prestigious role helping him publish academic papers. They started a sexual relationship during Landry's second semester. Dorsey was a 23-year-old student that year, asked career counselors to help her find a summer internship in antitrust law. They directed her to Wright. She told Wright that she was going through a divorce, and Wright said he was too. Later, he asked if she wanted to be a research assistant. So a great deal of kind of impetus has been put as well on the fact that when they started this sexual relationship, that they were both married. The difference is that Darcy was telling him that, you know, she was going through a divorce. Wright had told her he was not, right? And would not go through a divorce for another 10 years. Again, none of that excuses the fact that, and Wright admits to this in his suit, as we'll get to, he was engaging with inappropriate sexual relationships with students. I do not care about the rest of the story. I don't care how long those relationships lasted. I don't care that they're consensual. I don't care about any other part of that story. The point that professor sleeps with students is already an egregious violation of the power dynamic of the relationship and an abuse of power. Period. End of. Done. All right. It is not okay. If they wanted to engage in a relationship, they can totally do that when they are both not in that position. When that student has left, has a job somewhere else, and then they want to start a romantic relationship, 100% go for it. As a professor with a student, this is off limits 100%. I don't know why there's any conversation beyond this. Bobby Monkamobi says, oh, here we go. I'm separated. My wife doesn't understand me. Yeah, I mean, like, we know this playbook at this point. Like, oh. Anyway, that summer, Wright invited Darcy on a trip to Northern California, where he said he was meeting with executives. When they arrived at the hotel, Darcy learned that Wright had booked one room with one bed. Uh-oh. In that moment, Darcy felt powerless to say no to her law professor and now her direct manager, especially since he had made it clear that he was the gateway to obtaining a job in antitrust law, according to Darcy's response to Wright's defamation suit. Wright remained in a sexual relationship with Darcy and Landry during their years in law school and after they graduated. He found ways to remind Miss Landry that he had influence over her success as a student and the promise of her career. Landry alleged in her response to Wright's defamation suit. Landry said that Wright opened doors for Freshfields Brookhouse Derringer, a London-based law firm that represented Google and other companies dealing with antitrust regulators. After Wright was appointed to the FTC, he hired several George Mason University law students. That year, Wright also helped Darcy to get a job as an associate at Wilson Sonsini, Goodrich, and Rosati. So he got Darcy a job at the law firm he was at. He got Edwards a job at the law firm he was at. He got Landry her job at a different law firm. They also represented Google on antitrust matters. In 2015, he hired Landry to be his attorney advisor at the FTC. He'd also got Darcy a job at the FTC as well. Within a year, Wright was having affairs with Darcy, Landry, and Edwards, who was still a law student. He lived in McLean, Vermont with his wife and 3 children. For a while, none of the women knew about the others. One of the things that's never really talked about in this, when we have these conversations about sexual assault and consent, is if you are sleeping with multiple women and they do not know about each other, you have removed their right for informed consent. We very rarely talk about that in these situations, and especially when I've seen the conversation about Darcy about, well, you know, she was married, he was married, blah, 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 all of this stuff. Even so, you're right. Like if they want to carry on and do these things, not everybody here is able to give fully informed consent if they do not know that everybody that is involved in this situation. Already huge problems that I think are insurmountable. I don't understand how we go from this to then sort of victim blaming, and we'll talk about it at the end. But so I am now going to jump over to the George Mason defamation case against them, because it's got a good timeline of what happened in it that we will talk about. So is it in here? Okay, so what happens is, as we talked about, 2009, 2010, Wright begins affairs with, or inappropriate relationships, I should say, with 2 of his students, right? Elsie Dorsey, Angela Landry. I need to bring up my notes to make sure I get people's names right. Angela Landry, right? And he's also at some point engaging with another student Lindsay Edwards. We've already talked about previously he had had an inappropriate relationship with Brandy Wagstaff. There will be more. Oh, and Christy Laser, right? We talked about Christy. He'd propositioned Christy, and then suddenly the job's dried up. So we talked about how they ended up finding out about each other, and then the school received a complaint in 2021. This was the complaint from Elsie Dorsey. She alleged that Wright had begun a sexual relationship when she was a student at Mason's law school, and that Wright was a professor. He'd sexually assaulted her, pressured her to engage into a non-consensual sex at the beginning of their relationship. Dorsey also alleged that the relationship continued after her graduation, and when she ended that relationship, Wright engaged in quid pro quo sexual harassment and retaliation by removing opportunities to teach as an adjunct at Mason's law school and other academic opportunities. As required by Title IX, Mason opened an investigation and issued a directive to Wright and Dorsey that they were not to have any conversation with each other. At the point of this case and everything going on here, that investigation was still ongoing. We talk about the Baldoni playbook. On June 6, 2022, Wright submitted a Title IX complaint against Dorsey, alleging that actually she had sexually harassed and retaliated against him because, quote, she'd once yelled at him about the end of their relationship, she'd contacted other individuals associated with him, and told clients of his private consulting business about her allegations. 7 days later, Mason's then Title IX coordinator met with Wright. During that meeting, Dorsey's employment status was discussed, and Wright asserted that Dorsey was an active employee because of her involvement with the law school's online Masters of Law program. Combs further reviewed Dorsey's employment status, consulted with HR, and determined that Dorsey was not employed by Mason. So they couldn't bring a Title IX complaint against her, and so they dismissed it because Dorsey was not enrolled or employed at the university. Wright did not appeal the dismissal of his complaint as he was allowed to do so. A year later, in June 2023, basically it looks like George Mason are coming to the conclusion that they are going to finish out their Title IX investigation and that they are going to sanction him. So to get ahead of it, Wright submits his resignation and leaves Mason before they can finish their investigation. Shortly after his resignation, several women made accusations on social media that he had engaged in or solicited in sexual relationships with law students. I think that's this one. No, it's not. One moment. Not above the law. It's the Fortune. It's the Fortune one that I wanted. So he announces his resignation on June 2023. In doing so, a bunch of women come forward. In fact, it's 8 women in total that over 2 decades Wright had used his position and influence to proposition female student staffers and job applicants, promising career help, sending them flirtatious texts, inviting them on trips where he'd book only one hotel room, and engaged in sexual relationships with 3 of them. Several of them said they feared opportunities if they turned him down. We've talked about Landry, we've talked about Dorsey. There was Elsie Nelson, another one of Wright's former students. He was good at making you think you need his connections to make it, but the women he preyed on are extremely talented, smart, and successful of their own making. Nelson and 3 other women also worked for Wright, said he engaged in behavior that blurred professional lines. We've talked about Krista Laser, and how she declined his offer, and then his position suddenly dried up. So yeah. The FTC said that they were aware of Wright's inappropriate relationships, though it had no knowledge of any complaints. The agency-wide email sent out said that the allegations were deeply disturbing, encouraged anyone with information to report it. And then, of course, like we talked about, the Wilson, Socini, Goodrich, and Rosati, where Wright worked between 2016 and 19, previously investigated sexual misconduct claims against him. According to 3 people familiar with the matter, the firm declined to comment, except to say it takes issues related to employee conduct very, very seriously. So like you say, in total, there is 8 women that have come forward about him. This is not just Elsie Dorsey. It's not just her story. he had a long history of it. Again, there were complaints made before even his relationship with Elsie Dorsey by Brandy Wagstaff, and the university didn't do anything. Anyway, so his case gets dismissed, or his investigation gets, dismissed because he leaves. They still finish the investigation, I think. But anyway, so they talk to the press and, talk about his allegations. So in response, what does Wright do? He files a defamation lawsuit against Dorsey and Landry for it. In the lawsuit, Dorsey attempted to amend her complaint to say that the ongoing Title IX investigation against Wright, to add that he was now filing a defamatory retaliation lawsuit against him. Basically, the school looks at it and says, we're going to follow basically the Supreme Court's ruling about this, and then basically say that it didn't constitute as retaliation. And so they said, nope, Wright could not be found responsible for retaliation. So even though it was clearly obvious that that's what that was about, she lacked those protections, which is why she's filing the amicus brief, arguing that with her story, she needed those protections and didn't get them, and that had the California law been in place, things would have been very different to her. I think we talked about everything. I think we've talked about the timeline. I think now we'll bring up, oh, no, we have not. So yes, so this is the George Mason timeline. So along with filing against Elsie and Landry for defamation, he also then goes after George Mason for two things. The first is claiming defamation for even investigating these claims against him. I don't know did I bring it up? One moment. Did I bring it up? Dismissal complaint edited. Yeah, I did. So he then files against George Mason for a couple of things. Actually, you know what? We'll just bring up the pictures. I didn't really want to show you that. So in his lawsuit against George Mason, so one of the counts he goes for is selective enforcement. He argues, well, look, you acknowledged her Title IX complaint against me and you investigated it, but when I filed a Title IX complaint, you dismissed it. Mr. Wright and Miss Dorsey were similarly situated because they both filed Title IX complaints alleging retaliation and sexual harassment. Only Miss Dorsey's complaint was accepted and open for investigation. While the university indicated to Wright that it had no jurisdiction to pursue formal complaint because Dorsey was not enrolled or employed, it pursued Miss Dorsey's formal complaint against Wright even though he was not enrolled or employed. He was. And then it says the disparate treatment was caused by his sex. So he was trying to argue that basically you're unfairly targeting me and discriminating against me because you're not investigating my BS claim for Title IX complaint because she yelled at me, told other people about me, and then talked to my like the businesses you talked to my vendors and talked to the people I work with that I'd done this. And he was trying to say that constituted sexual harassment. He goes on to say here, by slandering Wright as a perpetrator of sexual harassment, Miss Dorsey subjected Mr. Wright to harassment on the basis of his sex. He's arguing that, look, just even alleging that that he caused sexual harassment, she has harassed me on the basis of sex. It's crazy. So he files that against George Mason. George Mason come back and basically say, look, if Wright's arguments were correct, every individual who reports sexual harassment would themselves be committing sexual harassment. If that were true, it would be impossible for victims of sexual harassment to report accusations or universities to address sexual harassment, defeating the entire purpose of Title IX. They also point out that, like, in pieces of this, look, the complaints are completely different. Her complaint was that, he'd carried on this inappropriate relationship for years. His complaint was that she shouted at him and told people about it. Like, these are not the same. As part of this, I can't remember if I clicked it in. They also talk about, they show emails that they showed that they sent out at George Mason talking about it. An alumnus from a class of 2012 filed a complaint in late 2011 about Professor Wright's conduct while beginning while she was a student, and that they are investigating. And so, yeah, a professor being moved out of a tenured position is extraordinary. The suggestion that the lawsuit did not take action is far from accurate. So, yeah, they talked about they limited him, and then, like I say, he ends up leaving. I think that's it for this one. I think the other one I wanted was his complaint. Here's the letter of his complaint. Here's his Title IX complaint against Darcy. Where he says, she's a faculty member. He witnessed concerning behavior about her. He informed her that he didn't want to continue the relationship as of October. And then she then showed up at his class, proceeded to yell at him. She contacted his girlfriend, that these contacts were unwelcome. She knows where he lives and of his custodial schedule with his children. After more than a decade of friendship in which he had never seen this type of behavior, it concerned Wright, and he became fearful for his and his children's safety. Again, he's the real victim here, and we need to be reminded of that. Not the professor preying on his students. Remember that. He's not. He's the victim. The professor preying on his students is the victim here. She then started stating to third parties that Wright had sexually harassed and assaulted her, that she shared these false allegations with his consulting clients. Again, this is what he's claiming is sexual harassment. Their false allegations were severe because they alleged falsely that Wright had committed a serious crime because they threatened Wright's status and reputation at the university and the general public. This all language sounds very, very similar to what we've seen in the Baldoni case as well. That, by saying this, they were alleging that Baldoni was a criminal of the worst kinds of crime, of sexual crimes, and that they were destroying his career and so on. At this point, it is a very worn-out textbook that we have seen from people when they get accused and alleged of this stuff. So anyway, that was in his Title IX complaint. His original complaint against Darcy, he again talks about it, that basically while he was teaching, they began a romantic relationship. He doesn't mention, of course, that she was his student. He just says while he was teaching, he met her. Both were married at the time, and both were married at the time, and both were aware of each other's marital status. Again, not pointing out that he was not telling the truth about the fact that he was getting divorced, or that Darcy was either. Wright and Darcy maintained a close relationship over the next 11 years, sometimes in a romantic capacity and sometimes not. When Darcy left law school in 2012, he wrote a letter of recommendation, got her job when she finished with her clerkship, including at Wilson, Sonsoni, and Goodrich and Rosati, which is where he worked, and he had got her position there. He talked there about how he got her positions at AFTC, the Antitrust Department Division of the Department of Justice. She successfully secured those positions. She left the DOJ. He helped her get a position at the University of Virginia. Indeed, through 2012 and 2021, he helped her obtain the fellowship at the UVA. Because of the course of the relationship, they traveled together multiple times. Outside of their romantic and professional relationship, they always maintained an intimate friendship, all of this stuff. So then he says, look, in late October 2021, he ended the on and off again romantic relationship with Darcy in a text message telling her he was seeing another woman. He also told her who it was. The other woman, who is now Wright's living girlfriend, was not just any other woman. Defendant Darcy had previously worked with her at the same firm. During that period, Wright and his other woman had been in a romantic relationship. Defendant Darcy knew about the relationship at the time, which overlapped with her own relationship, and she hated her. So again, this is the point of she hadn't known the whole period of the time, and the fact that she knew about it doesn't change anything. Well, she knew. So he then says basically that all of this is a destructive, vindictive campaign because he was seeing somebody else. But as you'll remember from the article we talked about over here, Dossie had known about this, the other person, all the way back in 2019. Him trying to then say that her doing all of this in 2021, 2 years later, was revenge for that, I don't understand the timing of that, but that's just me. He says he then also brings up that Landry, she's also lying and just wants revenge, and she's also a bitter, jealous ex that also happens to be a student that he had an inappropriate relationship with. He ended her relationship in 2016. When the relationship ended, she also lost her mind at him and hated him. And so all of this is just retaliation for him ending the relationship with her. He also talks about with her. He got her a job at the FTC. He helped her to join a prestigious law firm. Sorry, he didn't help her to do that. She joined that. That's on her own. But he does talk about, like, he got her other jobs. Like, it's all the same thing. But again, all of these women are lying, all of them. Anyway, he goes on to talk about them defaming him by talking about this. Christy Laser that we talked about, Krista Laser we talked about. She talks about it on there, saying that she had tweeted about it, or I guess, posted about it. Your action to file the Title IX complaint against Josh, the Harvey Weinstein of law, some have called him, is something I and so many women will be forever grateful to you for. Landry says, I've called him that, told it to him in his face, and he continued to conduct for years. They, again, are saying, defendant Lund treated that he was the Harvey Weinstein of law, intending to create the impression that Wright was a vile predator who forced women to have sex with him. We'll talk about the Harvey Weinstein thing at the end as well. But, like, again, just, I did nothing wrong. Like, why would these women say these things against me? He then, to kind of, like, make his point, includes a bunch of screenshots of the text message conversations, which, where have we seen this tactic before? And just like Baldoni, they are not complete conversations. They're fragments. So he talks here about, like, this is when he broke off the relationship. He says, I don't need you on the FedSoc call. Do not join WG call. Although as you thought might be happening, I am seeing Lindsay and I need time to cut off communications for the time being. I'm sorry I let you down. I'll make sure you get your stuff. What the actual F? I'm already on, so I'm not dropping off, and I deserve more than an effing text right now. It says, please don't worry about my things, but I still need you to give me work and pay me and write articles with me like we discussed. I've missed this piece, but part of it is he promised her that if she went to that the University of Virginia thing, that Google would pay her bills and do all of this stuff, and then she never got paid for the work, and nobody ever reached out to her. And then as the moment that he cut it off with her, he basically cut off all the work with her at the same time. So this idea that, oh, well, it wasn't like this quid pro quo, or that, he was directly admitting that, like, their relationship was tied to their professional relationship. There was no separation, because the moment that he called off the personal relationship, he also entirely ended their professional relationship and working together as well in the same moment. Says, please do not ask me not to join professional calls like RTP, because it's not fair to punish me professionally for my personal failures. She literally calls out, look, I get it. We're not a personal thing anymore, but there's no need to punish me professionally and like cut off the professional thing. He says, I didn't ask you not to join. I just thought you told me you were leaving. She wants to talk to him just so I can get a sense of closure. He says, I'm not ignoring. I need to pick up my kids. No need to apologize. Appreciate including me in the middle of me imploding and causing harm. And you're worried about me. I made my own spiral. I'm not trying to make it about me. Blah, blah, blah. We will talk. And then again, it says, okay, I hope you're enjoying time with, and then in contact with Lindsay. So again, he's not showing us the full conversations that's going on here. She then says, hey, I wanted to log into Lodestar to get some work done, but I seem to be locked out. Can you send materials to my Gmail? Reached out to Zach, but I haven't heard back. Or let me know if someone else I should reach out to. Could really use another project to dig into. Help me get my mind off things. Nope. And then, you promised me multiple times you'd be here, but you're doing the opposite. This is straight up effed up. I'm so embarrassed for thinking you ever respected me. I don't know why you're being mean. I don't know what I've done to end up it's so wrong in my life to end up in this total dumpster fire. And then he repeats the same conversation from before. Again, where have we seen this? Right? Where they just constantly repeat the same screenshots again and again, and you go crazy because you're like, wait, I've already read this one. And you can see here it says there's this whole piece now that we get that we didn't get before. So you're going to have to do better than that. Personally, you need to do better. How are you cutting off contact if I'm working for you? Again, pointing out the emphasis that like you can cut off the personal relationship, but not the professional. But he was doing both. I think at a minimum, you need to call me. You're going back to Lindsay after how horribly she's treated you, your family, and everyone else. You remember he got divorced because Lindsay had kind of let his wife know about his affair. But anyway, all of this to say, look, this was absolutely a bit of a mess. He includes then the text messages with Angela as well in 2016, where he says, "I'm walking away," and she said, "You were the one who told me you didn't want to be with me after 5 years. You can't blame me for leaving a toxic relationship. I was struggling because of you. You were what I wanted and you couldn't be with me." And so he's trying to use this to say, look at these women. They're so crazy, right? And it's like you've created this year-long dependent, like multi-year-long dependent relationships. You've completely abused the power dynamics to where they're completely reliant on you, not just emotionally, but also professionally. And then you cold turkey cut that off from them completely with no explanation, no understanding. And then you wonder why they're mad at you. Like if you ended any kind of normal relationship, that would still be a problem. To do so where the lines have been blurred so much here, right? In these completely abusive relationships where you have used your power over them, and to then cut them off and then be like, oh, they just don't know, like they're being all over dramatic. Like again, like where have we heard this? Like this feels exactly like freaking what's it, Baldoni's talk when he's like, oh, she shared all of her these things that she had going on and it was so over the top. Where is it? She had her set of grievances that appeared to have spent the past 5 days over-analyzing. From the outside, it was clear she had scrutinized every manner of interaction and perceived slight from the previous week. Women, they're just crazy. Woo! Like, it's such BS. And it's like every single one of these dudes. He includes the article that he's going after them for defamation for, which was posted on Law 360, which is when, after he announces his resignation, basically Elsie comes forward and shares her experiences. She talks about they were supposed to leave, no sexual contact had occurred, she said, but as they sat in the hotel bed, the hotel's bed, running late to catch their flight, Wright asked if he could touch her. This is after, they'd showed up at the hotel, but there was only one bed. He hadn't touched her or done anything previously, even though they'd shared that bed. I didn't say no, but I also didn't feel like I had a choice to do that in that moment, Darcy said. That led to the beginning of their sexual contact with Wright. According to Darcy, she never felt comfortable saying no to Wright, including when, she said, he pressured her to have sex in his office on the school's campus. She resisted, but gave in to get out of the situation. Darcy was Wright's research assistant at the time, and therefore her direct manager. He was very clear this had to be a secret, this was something we couldn't talk about, and that no one was supposed to know. However, Darcy said, she did tell a close friend at the time about her contact with Wright and the trip they took to California. Law 360 spoke to that friend, and that person confirmed that Darcy told him about it at the time. The contact continued throughout Darcy's law school years. Expected to graduate into 2012 into a tough job market, she knew she needed Wright's positive references. She ultimately took a job as an associate at a prestigious law firm, Wilson, Sonsini, Goodrich, and Rosati. And in 2013, Wright was nominated to be a commissioner at the FTC. Their sexual contact faded at that point. However, when Wright left the FTC and joined Wilson Sonsini as a senior counsel, he became her direct manager and the sexual contact resumed. So remember, he had got multiple of his law students positions at Wilson Sonsini, worked for the FTC, then left there, then went to Wilson Sonsini, where a number of the women that he'd had inappropriate relationships with as their professor, and then renewed those sexual relationships now that he was working in the same company and their direct manager. Like, what? This is insane. This is crazy. Baldoni supporters have gone out of the way to harass her and their LinkedIn and bully her. We're going to get to talk to that because that's the piece of mystery. I know we're already like way over and we're going to go to 3 hours plus again. But Yes, exactly that. I mean, this has just angered me. This is why I wanted to talk about this tonight, because I was like, there's so much here to dig into and nobody's talking about this, and this is super important. A former colleague of Darcy's at Wilson Sonsini told Law 360 that Darcy confided in them when they worked together that she'd been in a sexual relationship with Wright, and it had started when she was a student at GMU. So she shares her story. There she said she began, so this is when she moves to Charlottesville, Virginia. She worked for Wright on a contract basis, and Wright to begin help her with a fundraising effort for her fellowship. However, after Darcy confronted Wright saying that she believed he was engaging in a sexual relationship with another former GMU student of his, and he had lied about it, and that Darcy wanted to end things with him romantically, all those plans began to unravel. The contract work disappeared, the fellowship funding was delayed, and even the work at GMU ended abruptly and without notice. Then, near the end of 2021, Darcy filed a complaint against Wright with GMU, which included allegations of Title IX violations, including hostile environment, quid pro quo sexual harassment, as well as violation of the university's policies regarding consensual sexual relationships. Those investigations are ongoing. Again, Landry shares her story, talking about it as well. She said that Wright told her if she did well in her position, he could coach her, help her get a job after law school. He made comments that seemed to push the usual teacher-student boundaries. For instance, he said, pointing to her fidgeting, and asked if she was nervous, and then followed it up by saying, "It's cute." Again, where have we heard that from? Remember the whole, it's sexy, that's not what I'm going for, hot, not that either. I guess I missed the HR meeting. I mean, like, these are the same men. Like, how are we still being tricked by this? It just slowly escalated. It's a lot of this boundary expansion for months, she said. Then February, after she started law school, he kissed her for the first time, she said. From there, it escalated quickly. Landry said there were often times during their relationships that she felt she couldn't say no to Wright, and that he often reminded her of his connections and her sway when it came to her career. Those times it really felt like I can't make him mad, because if I do, he's going to take all this away from me, everything I've worked for and I want in my career. Sexual contact cooled for a period of time, then began again when Wright asked Landry to serve as an attorney advisor to him at the FTC. So when he went to the FTC, he took one of his law students that he was having sex with him, same as he did when he came back to Wilson Sonsini. Like, I think he took that as a joke or challenge. Well, Landry said she told him that she would, but he had to keep things professional. The sexual contact then resumed, she added. I always felt like if I made him mad, I would lose my job, my career, and everything I worked for. And again, this is proven out by what happened to Darcy, because the moment that she was confronting him about his relationship with other people, all of her work dried up. So this was not something that they were nervous about because he was giving them opportunities, and that all those opportunities would dry up. He would actively ruin their careers and stop them from getting any work. This wasn't just about they couldn't climb up the ladder or get opportunities. He controlled their career. He consistently made them aware that he controlled their career. And in the case of Darcy, tried to end her career because she made things uncomfortable for him. Like, and then they all started talking and sharing notes. I mean, like, it happens eventually. It happens eventually. I don't understand why he was not planning for this or thinking this day was never come. But again, they always think they're going to get away with it forever. During the time when their sexual relationship was on, Wright helped her secure opportunities to speak on panels, write papers, and contribute to antitrust profession. But after Wright left the FTC and joined Wilson Sonsini, she said, all of that changed. Once he was done with me, those things stopped coming. And remember, he ended the relationship with her in 2016 when he left the FTC to go back to Sonsini, or to go to Sonsini. He told me he couldn't even count the number of people he sent inappropriate messages to. Krista, we already talked about, so I don't necessarily really need to much go into, but she there talks a little bit, adding more details, talking about when we got to my car, he gave me a hug that was long and close, pressing too close to my body for a work meeting, she said. When I opened my car door and turned to get in, his face suggested to me that he seemed to realize I viewed this as a professional meeting, not a personal one. The next day is when she received the email, I hope this doesn't come off as overly forward, but I really enjoyed dinner and talking with you. The two never went on a date, and Laser was never offered a job. Yeah, so let's get into the Amicus brief, right? Knowing all of this background. So Darcy talked about, like, she's an attorney, an advocate for survivors of sexual harassment. Darcy herself is a survivor of sexual harassment, and like Lively, was subjected to a retaliatory defamation lawsuit. As a result of this experience, Darcy advocates for stronger statutory protections for survivors of sexual harassment, especially those who want to speak up about their experience. So, knowing the background of her, now you know why she is advocating in this lawsuit. A number of people have said, well, why is she coming into this? Because her particular background is very relevant to this case, and then also has set her up as being an advocate for others in that same position. Lively and Darcy's experience show that sexual harassment remains deeply entrenched in just about every industry. Sexual harassment derails careers, shatters confidence, and silences voices. The Me Too movement exposed the widespread nature of such misconduct and empowered survivors to share their experiences, but recent backlash has ushered in a troubled rise in retaliatory defamation lawsuits, which intimidate and stun survivors into inaction. These retaliatory lawsuits are a black mark on our legal system. Telling one story of sexual harassment is never easy. It's often a last resort. This is certainly the case for Miss Darcy. She saw coming forward as the only way to protect vulnerable women. She talks about she reported her former professor, who had conducted an investigation into lasting approximately 20 months, and found multiple causes for termination. After a protracted and costly process, Darcy and her co-defendant were forced to endure another 18 months of exhaustive, expensive, and intrusive retaliatory litigation. So she goes through to tell her story and the background, talking about Miss Lively. Where am I missing it? Oh, Darcy actually specifically calls out what I talked about, where Freedman is calling out the constitutionality of the Protecting Survivors Act. Wayfarer parties opposed Lively's motion, claiming her statements were malicious and fabricated. They also challenged the constitutionality of the Protecting Survivors Act. Page 12. Women, including those in high positions, face significant professional and personal costs. Protected classes experience compounded challenges due to race, nationality, and sex. So all of the stuff we talked about in the prior Amicus brief, Elsie's pointing out as well that it's not just that these things also happen to women in high positions. It's also the fact that protected classes experience this and face additional challenges as well in society. When employers often focus on legal expenses associated with workplace harassment, broader ripple effects permeate society. Sexual harassment carries significant personal, emotional, and psychological consequences for both those who experience it, those who witness it, including insomnia, depression, anxiety, and even physical symptoms such as headaches, nausea, and appetite loss. In the wake of Me Too, a surge of retaliatory lawsuits has emerged. These lawsuits pose significant barriers to survivors seeking justice, as the fear of a lawsuit alone deters many from coming forward. Not only is the legal defense expensive, it forces survivors to relive their abuse over and over, often in hostile settings like depositions and open court, which tend to be re-traumatizing and emotionally draining. She goes on to talk about her story, which at this point we now know, right? That she spoke up after he left his position, resigned from his position, and that he retaliated by trying to sue Darcy and Landry for $100 million in damages, which ultimately they were forced to, Darcy was forced to settle for, and I believe the case was just dropped against Landry. She talks about her story. She was a 23-year-old in 2009. And that he began an inappropriate conversation with her after a trip to California, and that it carried on, that he got her positions, and then, treating her stories. Darcy filed a Title IX complaint. He eventually announced on Twitter his plans to leave George Mason. That Twitter post prompted a wave of backlash with a slew of new allegations. A female law professor came forward to share how Professor Wright positioned her when she was seeking a position on the faculty. This is Crystal Laser. It says Miss Darcy galvanized and then decided it was time to share her own experience in the Law 360 article that we just covered. It morphed into a devastating legal battle that would cover the last 18 months, because he would come and sue her then for $108 million in damages. Throughout discovery, Wright would admit to sexual relationships with at least 7 students, 2 additional subordinates, often overlapping. Virginia's weak anti-SLAPP statute failed to protect Darcy. After Darcy filed her Title IX complaint, George Mason hired multiple outside investigators and launched exhaustive investigations lasting nearly 2 years. Several current and former student employees were interviewed, and a consistent, inescapable picture emerged. GMU ultimately determined that termination proceedings were warranted based on violations by Wright of multiple university policies, including those on professional ethics and consensual relationships. After all of this, Darcy then endured another 1.5 years of expensive and burdensome retaliatory litigation that her harasser had used as a tool to punish her. It is important to note that he brought that defamation lawsuit against her, and he prevailed in bringing that against her, forcing her to settle, even while the investigation upheld her complaint that he was suing her for, or at least the article that she wrote about the allegations, right? So the university upheld that, yes, he had carried on these inappropriate relationships, and yet she still was not able to prevail in that lawsuit, and he was able to bring a retaliatory defamation case against her. Important to point out, Wright admitted to texts in Friends that he was just doing this for, to ruin her life. Maybe defamation for fun, but not to win. And that he wanted to bankrupt Miss Darcy and the other defendant for speaking out. He texted a friend saying, "You'll be pleased to know my brief to the mediator calculated my damages from these blood-sucking harlots at a minimum of $2.5 million. Following a dispositive motion, he added, "Now we start to cook. Drop expensive document requests. Passing motion to dismiss means I can do that and raise the cost." The week before the case was set to go to trial, Darcy settled through an insurance carrier for less than 0.3% of the $108 million in damages he had sought, a sum far below what the scheduled 3-week trial would have cost. Wright non-suited the claims against the other defendant. I have questions. Lol, says the junk farm. Feel free. Mio says, thinks of those. I think his combination of me, I loved him and wanted to please him. Drunk on being the trusted insider with power and maybe a degree of confirmation bias and echo chamber. Who? Oh, never mind. Y'all are talking about something else. I'm like, wait, what? He was still a professor because he had a circle of friends with similar behaviors on the board. Because they manicured those relationships. Ugh. Yes, I mean, it's always not just the men who do this. It's also the circle of people around who look the other way, who empower them, and also, help them to retain that power. It's craziness. And Massey Jinx says Johnny Depp had already been found liable for 12 instances of abuse, but he was still able to sue Amber in Virginia. Yep. Yep, unfortunately. So yes, so even having settled that, there was not a non-disparagement clause. Part of her agreement and settlement was that she would still be allowed to speak out and talk about this, which is why Darcy's still able to talk about her story and put this out there. So this is why she's bringing this up, because obviously she has personal relevant experience in this, and wants to point out that, look, despite efforts to protect survivors, many state anti-SLAPP statutes remain woefully deficient. In Virginia, Darcy and her fellow GMU law graduate were subject to the weak protection of Virginia's anti-SLAPP statute. In contrast, Blake Lively has invoked the much stronger protection afforded by California's anti-SLAPP statute. California's Protecting Survivors Act was enacted to give survivors a clear, unambiguous pathway to justice when facing retaliatory SLAPP lawsuits intended to intimidate, silence, and financially cripple them. The damages provision, a provision lacking in Virginia, is central to the strength of California's statute. The remedies are an indispensable tool designed to meaningfully deter retaliatory conduct, level the playing field, and affirm California's commitment to protecting its survivors. Invalidating these provisions based on Mr. Baldoni and the Wayfarer Party's expansion of the no-opending doctrine would dangerously undercut the statute's purpose and have a severe chilling effect on survivors' ability to safely report abuse. This court should not invalidate that crucial remedy, which is foundational to the integrity and purpose of Protecting Survivors Act. Talking here about this Protecting Survivors Act aims to promote transparency and accountability via legal remedies, reinforcing California's commitment to protecting survivors' rights to free expression of their stories as matters of public concern. Unlike Virginia, the California legislature created a statute with significant deterrent effect. It's not toothless. The Protecting Survivors Act mandates attorneys' fees and reasonable costs, treble damages for the harm caused by bringing the claim, and punitive damages for defamation claims brought against it. These remedies are essential to fulfilling the statute's core purpose because they deter retaliatory lawsuits and eliminate the strong financial disincentive survivors face when speaking up. And again, important to call out that the strong financial disincentive survivors face when speaking up. Again, knowing that you're going to speak out is going to open you to these lawsuits, is going to force you to be dragged into court in the same way that Wright had done to Dorsey, in order to get these people to silence. Without these remedies, even prevailing defendants may be left in financial ruin. This risk often silences survivors, undermines the statute's protective function, and reinforces the notion that silence is a safer option. Again, important to call out, even if you prevail against the defamation case against you, without these protections to get lawyers' fees in return, you have had to spend an inordinate amount of money just to defend yourself from accusing somebody of sexual harassment. If they don't put these protections in place, what that means is people with more money and power can use these lawsuits to drain the resources of people who don't. That is why these protections are in there. This is why there is these the fees in here, and attorney's fees are in here, is to remove that power imbalance, so that then they are not faced with, oh my gosh, I have to do this lawsuit. So does the second form of retaliatory behavior, defamation, add on to the smear campaign retaliation to strengthen the case, increase potential punitive damage? That is a good question, Miha. That I don't know. I don't think so. I don't think it's going to be taken on to be put on it. I think what's going to happen is it strengthens, I think, more the argument about the Rule 11 sanctions, I think. Because, again, it's not just that you couldn't bring any of this against them. You also knew you shouldn't have brought the defamation as well in the first one. But I don't know. I love when the stands prove the case against livelihood. I bet you believe Amber Heard too. Like, yeah, shocking you fell for that one also. Hey, you dummy. Yeah, and we'll talk about this as I wrap up in here. I promise I'm getting there. I appreciate you guys hanging with me past the 3-hour mark. But we'll get to that. We're almost there. We're getting close to landing this plane. Absent of strong remedies, moreover, may force survivors faced with a wrongful retaliatory lawsuit to settle with their abusers despite valid and truthful defenses, strictly to stop the financial bleeding and emotional trauma that the lawsuit itself caused. This is exactly what happened to Dorsey. 23... Where is it? Argues that these remedies must be available at the earliest stage, typically through a motion to dismiss, to protect survivors from a punishing, protracted legal process. This is essential because forcing survivors like Dorsey to endure discovery or trial to prove their truths undermines the statute's core principle. Again, doesn't apply here in Lively's case. Lively was having to go through trial and discovery anyway because she had brought a case against Baldoni. But again, we're not talking about Blake Lively, right? A misconception of these amicus briefs is that they are advocating for Blake Lively, that they are backing her. They are in a way, but they are not encouraging the court to think about it just applying only to Blake Lively. They're encouraging the court to think about this being applied to average citizens, average private citizens. She talks about the Wayfarers Party's no impending challenge is an improper collateral attack. They're arguing that, you know, in their motion to dismiss, they're like we talked about, right? They said, well, you know, Rule 11 says that there could be sanctions, whereas this mandates sanctions. And she argues here that they're trying to say then that Rule 11 is both the floor and the ceiling for permissible sanctions, that nothing could be stronger than Rule 11 and nothing could be weaker than 11. The Protecting Survivors Act illustrates how states can create fulsome targeted remedies that supplement those permitted under Rule 11. The Wayfarer Party's misrepresentation of the no impending doctrine, suggesting that any law imposing consequences other than those embodied in Rule 11 would infringe on the right to petition and therefore be unconstitutional, this essential state power would be stripped away if they prevail. Survivors would be forced to choose between silence and financial devastation, while moneyed harassers would face little deterrent against leveraging their power and resources to intimidate and silence through litigation. Important to remember. Go think back to the Travis Flores case, right? That Travis Flores brought against Baldoni when he was represented by Bryan Freedman. And Bryan Freedman had told Travis Flores, this guy has a ton of money. He will financially devastate you if you try to pursue this. You need to settle and drop this, right? That was what Freedman advised Travis Flores when he had sued against Baldoni. Baldoni is doing it again here, is what we're seeing. The Protecting Survivors Act was enacted for the exact purpose and intent that Blake Lively raises, to prohibit the type of vexatious slap litigation Baldoni and Wayfair parties have filed against her for speaking out about the sexual harassment and retaliation that she experienced. And then for these ongoing reasons, Lively should be we should allow Lively to invoke the Protecting Survivors from Weaponizing Defamation Lawsuits Act in this litigation, and it should deny Baldoni and Wayfair parties' attempt to undermine the Protecting Survivors Act for survivors. So with that, Freedman has already written a motion in opposition to allowing these amicus briefs onto the docket. This is crazy to me. An amicus brief does not change anything. It does not impact anything. It is simply extra information that the judge can use in making his decision. There is no reason that Freedman or Baldoni had to issue a response here. The optics alone of this are terrible, right? If they really thought they were unconvincing and weak, they should have just left them alone. Instead, Freedman posted this message to Lyman, arguing that they shouldn't be allowed to put them on the docket. So firstly, he says, there are filing for leave to file in support of Blake Lively's motion to dismiss, which was fully briefed months ago. As described below, the court should deny the organization's motion for leave to file an untimely partisan amicus brief that merely serves as a vehicle to renew Blake Lively's public attacks against the Wayfarer parties. Again, flip it, we're the victims here, they're attacking us. Repeat arguments previously made by Lively and raise issues that are irrelevant to the pending motion to dismiss. Dude, you summoned them by arguing that the law itself was unconstitutional. It is in your opposition to the motion to dismiss. Not only is it not irrelevant, you summoned them. You could have used anything else. In fact, you could have just removed that part of the argument from your opposition to dismiss. You could have said it was defective for her, because it was conflicting with Rule 11. You could argue that, she had pled her complaint with malice. Totally fine. You brought them here by saying, no. Even if all of those arguments fail, the law itself is unconstitutional. You brought this on yourself. Like, this is wild to me that he's now blaming Blake Lively for this when you summoned the people who crafted the law by telling them their law was dog shit. Like what did you think was going to happen? While the Wayfarer parties respect the three organizations seeking amicus status, their brief fails to aid the court in its task at the pleading stage. If for any reason the court grants the organizations leave to file a brief, the Wayfarer parties should be permitted to file a responsive brief. We should have an opportunity to go fight with advocacy organizations about who best understands and represents sexual harassment survivors. Why would you file this in court, you insane man? I don't know. I don't know why they would put this here. And again, think back, I know it's been 6 months. This was a man who made his platform on being an ally to women and encouraging men to make space for women to speak up, even when it's about you. Now we're at the point of, no. If they're allowed to talk, you need to let me go fight these advocacy organizations and tell them where they're wrong. Bravo. This is insane. Was it something we were talking about earlier, Davo or something, right? I mean, this is wild. Heidi the Sausage says they cannot get in their head around somebody holding them accountable. And again, none of this has anything to do with Blake Lively. This is entirely about you making the argument that the law that was crafted is fundamentally broken and unconstitutional. You brought this fight. You brought them to this, and now you're saying, I want to be able to have a go at them. What? As an initial matter, the organizations filed their belated motion with Lively's consent almost 2 months after the motion to dismiss has been fully briefed, enabling Lively to resume unwarranted attacks on the Wayfarer parties with inflammatory comments to the press. After the stunt with Taylor Swift, what? This motion serves more as a publicity stunt for Lively than a useful aid to the court at the pleading stage. I've talked about how almost always their arguments are no you, no you, no you. And it's crazy to me after Lyman gave them the warning about that they're doing this publicity stunt and we're going to strike it from the record. Their next opposition is, well, no, you're doing a publicity stunt. Okay. What is wrong with these men? Power. Yeah. No, every time, right? They get a whiff with the whiff of it. And again, we talked about that like with the Impractical Jokers guys. Like, what are you talking about? Like, they get a little bit of fame and power. What do they use? They use it to groom young women. A professor at a university gets a little bit of power. What does he do? Uses it to groom young women. Like, I don't know. Why could one of you not like use it to, you know, find a cure for cancer? I don't understand why it's always, man, now I can groom young women. I don't understand it. They argue that it should be denied because neither it nor the proposed brief satisfies the limited conditions. The circumstances under which an amicus brief is considered to be an aid to the court are limited. An amicus brief should normally be allowed when the party is not represented competently, or is not represented at all, or when the amicus has an interest in some other case that may be affected by the decision in the present case, or when the amicus has unique information or perspective. Yeah, that seems to have been met. He goes on to make a dig here. He says the organizations do not assert that Lively's counsel is incompetent, nor did they identify any other case that may be affected on the motion to dismiss. Rather, the organizations rely on their unique perspective as drafters and champions of the bill. And he puts this in quotes, like, as drafters. Like, no, they literally, like, co-sponsored the bill, my friend. Like, which is another way of saying the organizations attempt to provide disguised, premature, and inappropriate expert testimony at the pleading stage. As observed by the Seventh Court, the vast majority of amicus briefs are filed by allies of litigants, and duplicate arguments are made in litigants' briefs, in effect, merely extending the length of the litigant's brief. Such amicus briefs should not be allowed. They are an abuse. So he's saying that they shouldn't be allowed to have their say in this case. So again, he's shutting down the voice there of ally organizations and advocates for sexual harassment. I don't know, again, why you would put this in writing, but this was the bit that really got me. And this is why the title of today's episode is Ally No More. While the Wayfarer parties respect the work of these organizations, they are not neutral friends of the court, but rather advocates of specific policy interests that align not only with Lively's defensive posture, but also her affirmative claims against the Wayfarer parties. He's literally putting out and typing on the internet that the Wayfarer parties are misaligned or are deliberately opposed to the policy interests of sexual harassment advocates. Again, this is a man whose entire platform was built on advocating for women who make claims of sexual harassment. It is wild to me that you just openly put out here that your entire platform is just you taking a match to it and burning it to the ground, especially like as he's talking about, he wants permission from the court to go toe to toe and go fight with these advocacy organizations. Why do you think that's a smart idea? The proposed brief focuses on the need to avoid abuses of discovery in sexual harassment cases, which is not an issue. It's an issue that was not raised by Lively and did not move for a stay of discovery. And again, they're not talking about this case. They're talking about how to claim the law in terms of other cases and for other people. He says discovery is well underway. How many motions to compel do we have on the docket right now? Like, what are you talking about? Discovery is underway. They still have not provided a date that they're going to be finished with initial discovery and ready for exchanging the electronic discovery with Lively's team that we've seen. So like, it's crazy to me. So yes, but this is the piece that got me was also as well of this. While the federal rules of civil procedure do not address the submission of amicus briefs, district courts have looked for guidance to Rule 29 of Federal Rules of Appellate Procedure, which provides that an amicus brief and motion for leave must be filed no later than 7 days after the principal brief of the party being supported is filed. This is insane. He's admitting here the rules of civil procedure don't address the submission of amicus briefs. It is entirely up to Judge Lyman what he wants to do here. He's now giving Lyman advice on how to run his court, and he's doing so by pulling the rules of appeal court and telling them that, oh, this should be filed no longer than 7 days. No lawyer has put forward this motion. This was an idea that was put forth by a content creator who is not a legal person, has no legal education, who was making this claim the very day that the amicus briefs were filed, and now Lyman is basically putting a Reddit theory in Freedman is now putting a Reddit theory, a Reddit conspiracy in his filings. This is insane. Like, he's literally quoting people off Reddit now. Like, this is where he's pulling his legal stuff from. He is empty of any legitimate argument. That's nuts to me. And again, I talked about this on Threads, but like, if you send me this bill, I'm throwing it in the trash. I am shredding it. I'm not paying for you to go quote somebody on Reddit. That's nuts. Yeah, so anyway, he's saying they filed their proposed brief 2 months after Lively filed her motion to dismiss. But it's not about her motion to dismiss. It's about your opposition to her motion to dismiss, which, I mean, it was close to that, but I forget when they filed that. What was that? 4-3. So, you know, almost 2 months. Almost 2 months to when he filed his opposition to it. So yeah, fun times. I don't know why they would put this in here, but yeah. So he's saying we shouldn't be allowed to put this in here. This, however, isn't even the worst of it. Looking at the internet, which is obviously, you know, a cesspool, we've talked about that a lot. Almost immediately, people were calling out Elsie Dorsey and saying that she was not a victim. Check her lawsuit, she's not a victim. Other YouTubers have talked about it and said that her whole case, you know, because she was married, the guy was married, they had a relationship for 11 years. She, you know, only got upset when she found out that he was, you know, having a relationship with other women as well. Like, they've used all of this to once again say she's not a victim, she doesn't do it, she doesn't deserve it, you know, and to go and harass her. As we talked about in chat, she posted the entire amicus brief to her LinkedIn page. Almost immediately, Baldoni supporters were sharing that link amongst each other and encouraging each other to go leave comments on LinkedIn and harass her, which is what they did. And when she started to delete those comments, because they were just mindlessly attacking her and harassing her, they then attacked her for deleting comments and, you know, silencing people and not wanting discussion. And it's like, it is insane to me that you would go harass a victim of sexual harassment, that you would go harass somebody who advocates for people who advocates for victims of sexual harassment and think that you're in the right. Like, if you disagree with her, great, disagree with her, leave it alone. Don't go into her LinkedIn to go start a fight with her and then get upset when you get blocked or your comments get deleted because they don't want to hear your nonsense. It says here, you know, Darcy had claimed 100 years ago when she was had a claim 100 years ago when she was a student to come out after an 11-year relationship while the guy they were both married and after he had helped her advance professionally is ridiculous. She's a scorned woman. She's pissed that he dumped her for another woman who she reportedly hated. She's another abuser of the legal system for her own personal gain. How do we end up like totally forgetting about the professor who was sleeping with multiple students? Like, how is that not the headline? How does it suddenly become, oh, it's the woman, and we need to go after her, she's the problem here? But all of this reminded me of, I'd done a video a long time ago. Some of you might remember, I don't know if you, a lot of the YouTube folk are, you know, follow me on TikTok or watched all of my old stuff. But a long time ago, I did a video responding to Matt Walsh's absolutely insane rant in his car. And yes, that is Matt Walsh, where he was talking about a number of different topics, but he was talking specifically in response to Theodore McCarrick, who was a Catholic cardinal who had been found guilty of, well, I say guilty, had been investigated by the church, I think. I shouldn't say found guilty because it was not a lawsuit or anything, of sexual misconduct. There were a number of seminarians who reported sexual misconduct, but one of the things that McCarrick was alleged to have done was he would go on trips with these seminarians And it says, I had the impression that virtually everyone knew about it, Ramsey said. Archbishop McCarrick was inviting seminarians to his beach house. There were 5 beds and 6 people. Archbishop McCarrick arranged it in such a way that somebody would join him in his bed. Exactly the same thing that Dorsey had described about Joshua Wright, where you set up a situation where, like, no, there's not enough beds, you'll have to sleep with me. Like, again, these men are all made from the same fucking mold. But in his little rant about all of this, Matt Walsh had made the same point of, well, you know, these seminarians, some of them were adults, and you know, if you climb into bed with as a grown adult with another man, then is that really sexual assault? Is it really sexual assault? Like, it's a disgusting video from him, and I made, you know, a couple of videos off it. It's gross. It's disgusting. It shows a man who does not understand the topic at all. But he basically made the point that unless you were fighting back, kicking and screaming, then it's not really non-consensual, is it? Right? Like, we're stretching what consent means. It's insane to me to watch people fall over themselves to defend this inappropriate use of power over people, and not to fully understand at all any of the abuse dynamics. And it's funny because we talk about it so openly for, like in my situation, right, with domestic violence. We understand that it can take a long time for somebody to leave a domestic violence situation, that they don't often recognize that it is abuse in those situations, and that even when you do, there's a sense that you recognize that it's abuse, but you're in the relationship because, you know, they'll change or they'll do this or whatever. And even though there's so much of this shame around some of this stuff, we don't ever talk about, like, well, you know, you knew it was abuse, right? But you stayed, right? But we do it for victims of sexual violence and sexual misconduct, of like, well, you know, if you put your face at the end of his fist, you were really asking for it, really, weren't you? You know, you had your face in the way of his fist. It's crazy. And that's exactly what we're doing here with Elsie Dorsey, and taking her story and saying, well, you know, she wasn't exactly kicking and screaming for 11 years, so therefore, is this really misconduct? Is this really harassment? Is this really him abusing his power? He got her, like it says here, he got her a job, right? Like the quid pro quo thing. So, you know, she got the quid. So, you know, where's the harm in the quo? Like, and again, it reminds me of like this video by Matt Walsh, because he also covered this when he talks about Harvey Weinstein. And he talks about Harvey Weinstein, and he talks about the actresses that came out making allegations against Harvey Weinstein. And he talks about the fact that, you know, oh, they're saying that Harvey Weinstein wouldn't like get them a movie unless they slept with him. But if you take that contract, if you take that deal, if you say, okay, I'm going to sleep with him, and then I get a movie out of it, it's like, well, you got the movie out of it. So is it really, again, like he was making the point of like, is that really sexual misconduct? And like, yes, a man withholding opportunities, withholding these things in return for sexual favors is sexual misconduct. There's not a question of it. It's not up for debate. It's not something that's ambiguous. It doesn't need a whiteboard to track out. If you're saying, hey, I'm only going to give you these career opportunities if you sleep with me, or even if you're not explicitly stating it, as in the case with Dorsey, where he was sleeping with her, giving her these career advancements, and then the moment that he was no longer sleeping with her, just ends everything, will not have a professional relationship with her, you know, pulls the plug out, all of her contracts dry up, all of that stuff. Yes, that's abusive. Like, it's wild to me that we are still at a place where this needs to be explained, or is it even a question? And when we go back to, oh my gosh, what was the other point? I've forgotten my other point. I'm gonna have to go crawl back up into chat. But yes. You're hoping for the best, says Marcy Jinx. Yeah, exactly. And not counting the video of him verbally abusing his wife, or was that Crowder? That was Crowder. Yeah, I know. All of these men all blur into the same one. But yeah, no, that was Crowder. Matt Walsh blamed women's clothes. Yep. He did, and I've also talked about that as well. I think it was that I was going to talk about the quid pro quo, but I'm forgetting now. But yeah, so that's everything I had tonight. So I'm going to wrap up with a little bit of chat. if you've got anything else you want to talk about, but I just want to say, like, this is why this case is so important. This is why I've been on a 5-month kick now, where like I have so much going on in my life, I can't make other content, but I'm dedicated to continuing making this content and talking about this because it is so freaking important. Because it's not about Blake Lively, it's not about Justin Baldoni, it is about the precedent we set and how other people who are watching this, who are survivors of sexual violence or violence generally, look at this, see how they are treated, and then make an assessment on whether they want to speak up and talk about what they have been through. And I've talked about that multiple times and from the very beginning of this. And I'm really appreciative of both groups for coming in and filing their amicus briefs to talk about this and really recenter this conversation on it, especially after the ridiculousness with the Venable lawsuit and Taylor Swift and how this whole stupid thing has got dragged into like this PR gossip tabloid nonsense. I really appreciated having the conversation refocused and recentered on where it should be. A woman made multiple complaints about feeling unsafe on set. Let me bring that up. All right, I've shown this before. I'm going to show it again, right? This was a workplace. Second day of the workplace, there was a complaint about unsafety on set. Right? The next week, there were three separate, well, I say three, there were three separate days of complaints. But as we talked about when I went through it at the very beginning of this series, reading receipts, I think like either episode 1 or 2, or maybe even 3, might have been episode 3. On the 23rd, there were like 3 separate incidents just on the 23rd alone. Then there was the 25th, the complaint about being exposed to COVID. 29th, Sony tells Wayfair about the complaints of unsafety. And then June 1st, as we showed, this is when Lively shares those grievances with Baldoni. He'd already been told by Sony, you know, of the sexy comment, the video including nudity. He'd apologized for it, said that there were adjustments, but the next day, and I think this is what's wild to me, is like, I'll bring up his friggin' chart again, right? Oh, it's not the next day. There's 2 days. There's 2 days, sorry. So between the 30th of him saying, oh yeah, you know, you've made these complaints. I hear you, they're fully received, we'll make adjustments. June 1st, oh, then suddenly you're overanalyzing, you've scrutinized every minor interaction and perceived slight. Where's the fucking apology gone? Where's the, I've heard your concerns and I hear you and I will make adjustments? Where's that disappeared in 2 days? Now we've gone from, I hear your complaint, I'm going to make changes, to, good God, women, huh? Lol. Like, crazy to me. Anyway, so like she repeatedly made these complaints. Like, and this is what this case is about. How do you deal with this in a situation where your boss is also your boss is also his boss is also his boss, right? Where the actor you're trying to complain about is the director, is also the owner of the studio. And when you talk to the distributor, they say, don't take it up with us, take it up with the studio. She's like, I can't, he's the owner of the studio. Like, who do I go to for help in this? That's what this case is about. And Baldoni himself admits it, again, in his own timeline. I hear you, fully received, adjustments will be made. She's nuts. In 2 days. In 2 days. And how do you deal with that? Like, if you're an actual employee in a workplace, how do you deal with an environment where the people who are supposed to protect you, who are supposed to provide that environment that keeps you safe, are the people who are harassing you, making it uncomfortable, and then refusing to do anything about it? So, end of my soapbox. All right. I will go into chat. So if you've got questions or anything to say, now's your time to say it. There are some fascinating psychiatrists who talk about our innate need to avoid pain. We work to forget and convince ourselves things were not as painful or as big as they were, says Miha. As a defense mechanism to avoid feeling pain. Yeah, this was a big eye-opening thing for me, and it'll be a lot of my content when I start making content again. I'm going to be talking a little bit around this. I had not realized just part of how the human body, when it expresses pain, if it gets to experience that too often, the body starts to numb itself and shut that pain down because it no longer likes feeling that pain and it's not getting those needs met. And so, as a defense mechanism, the body just shuts these things down. It shuts down emotions, it shuts down different pieces of processing, it shuts down different wants and needs because they're not being met. And then those get baked into our personality and we think they're character traits. And no, it is emotional damage and trauma that we have patched over. It is a coping mechanism. And then part of realizing our true selves, to get a little woo-woo, is to realize those are actually broken and damaged pieces of ourselves, not innate characteristics of our personality. And as part of my journey, that has been huge, of realizing a lot of those things where I'm like, oh, I just like to be alone, or I like to do these things. And then I'm like, oh no, that was a coping mechanism because of things I experienced in childhood. Like, it's not a great feeling. It's like, it's not a personality trait, it's trauma. Like, I need that on a t-shirt or something. It's like people forget what coercion is. Yeah, and again, like, we understand it. If you switch a lot of these situations to like domestic violence situations, that coercion, that feeling of fear is a lot more present because it's physical violence. But when it's sexual violence, I guess there's just such this innate nature we have to excuse it, that is all part of, the culture. I got to be careful of what I say here on YouTube, but I'm sure you understand. Of the culture that we have of excusing whenever it is. It's what you're wearing, you were asking for it, you didn't fight them off, you didn't say no. All of those same underlying pieces of excuses that we use whenever there's sexual misconduct, I think, shame and rear their head here because we're so averse to actually holding anybody accountable for their behavior in these scenarios. If it's sexual harassment, if the stake stopped, the job was gone and the opportunities were lost, it says Obi-Wan Kenobi. Yeah, 100%. And he was telling new victims about his crazy liar old victims. They always do, right? All my exes are crazy. Always red flag, red flag. Master Jig says the point was quid pro quo that goes on for a long time is still harassment. It is. And again, like, that you never can really escape it, especially if you are in that position. In that specific area of law, antitrust law, which a lot of them were. He, had a government job, was very powerful, worked with some of the largest companies. So, like, yeah, of course. Thanks, says my lady. I really want to do a part 3 to my series of AB933 explainers now with Darcy's brief. My lady, I didn't know that you had them. If you can you drop me a comment on this video or something and link and share those so that I can learn, and then hopefully other people can as well, because I would very much love to watch those or read them or wherever they are. Definitely share that content with us, please, if you don't mind. Let's see what else we got. Heidi Sausage says they won't take no for an answer. Yep. Obi-Wan Kenobi, so sad they need to protect the man, comes at the expense of women. It's heartbreaking, says Heidi. Yep. My lady, yes, this case will have effect on all survivors. Been saying this since day one. This isn't just about Blake and your personal opinions about her. 100%. Though my opinions of Blake have improved since investigating this. I feel the same way, mine. Like, I did not know much about Blake Lively. I knew of her. Like, I knew her in Deadpool and Wolverine. I'm like, oh, like, it's good to see her in there. But I knew a little bit about her movies and that she'd starred in Gossip Girl, but like, I didn't know much about her personally. This case really has kind of changed my opinion of her, and I do think, this is where I speculate, but I do think if this does go to trial, we will see that Lively was not acting out of personal interest, but out of interest for protecting multiple people, because it does seem like things do not really kind of escalate until the May 26th conversation, where she realizes it's not just her, but there's also other people being uncomfortable, and it's that really gets her then to talk to Sony, get to escalate this, and then gets frustrated by the fact that that ultimately doesn't go anywhere either. Obi-Wan Kenobi says, how a sexual harassment lawsuit became about Taylor and Blake, who is friends with who and who is baffling and beyond pathetic. 100%. Again, it's all just distraction, right? I mean, we talked about this from the beginning. They'll talk about the people. The abuser will talk about the people and the characteristics. The person who's being abused will talk about the abuse, the behaviors. I have a phrase that I use a lot. We attack what's it? Process, not people, or behaviors, not people. That is always how it should be, right? And if that's what you're actually looking for, change in behavior and resolution, that is where that conversation will stick. The moment that it turns specifically to the person, now you're just attacking character. You're not actually dealing with any of your problems or wanting to change behavior. You're not trying to bring about meaningful, impactful change. You're just trying to make the other person feel like crap. So always watch out for that. Master Jinx, it's only your career writing and can continue in the quid pro quo. You should have said no, type P. Yeah. Yup. You didn't fight hard enough, says our scientist. Yeah, and it's frustrating that this is just, I think we all had hoped that we had moved on from this. We all hoped that we had learned maybe a little from Amber Heard. We'd all feel like we'd learned a little from Me Too. And like things like Baldoni's, TED Talk, right? I mean, it's, I'll say this. There's definitely a lot of it that I don't like. And I tend to not like when I see somebody talking in that way, because it does feel a little fake to me. And I'm not saying this to say, oh, I always knew he was fake kind of thing. I'm not saying that at all. I'm just generally don't like that kind of way of speaking, because it seems false to me, right? And it's not to say all the people who do speak like that are. It's just more, it wasn't very impactful for me. But that TED Talk, like, you at least see somebody talking in that way, and it seemed to resonate, right? 7 million views or whatever it is now. It seems to resonate, and it built a platform, that was highly supported. It clearly resonated with people. People were encouraged by seeing, oh, this person gets it. And I think we all feel like, oh, we're moving forward. There's progress. We're learning. Things are getting a little safer. And then something like this happens, and then we see the absolute outrage from the internet, the way that the misogyny was always there and just is a torrent, an unrelenting torrent that doesn't just go after Blake Lively, but anybody connected to her. Now Elsie Dorsey's having to face it all over her LinkedIn because she had the audacity to file a brief in this case. Like, it's insane. And I think it's so incredibly disappointing to all of us that, like, we're so much further than we thought we were. But I am grateful for the people who continue to advocate, who show up every day. The folks like, the equal rights advocates and, gosh, I forget the other group, but the other groups that are represented in the Amicus, because, they are out there doing that work every day, advocating for survivors, changing laws, passing laws to make things better so that we are moving forward little by little. What we do need now, though, are absolutely these sorts of protections from harassment on social media. And I would love to see us actually move forward with meaningful laws that help to protect people from online harassment. What that looks like, how that happens, I do not know. If you have ideas, let me know. I would love to work with you on this. That's where we'd love to go. So on that, I will end this. I want to say appreciate you guys for hanging out with me. Thanks for sticking it out for almost 4 hours. Appreciate all of you. My lady, Master Jinx, our scientist, Heidi the sausage, Miha, Junk Farm. Trying to scroll through, see anybody else that I missed. I think that's everybody. Well, I appreciate y'all. Thanks so much for hanging out. We'll do this all again next week. Hopefully there will be a little less on the docket. If there is, I don't know what I'll be talking about. So if you have something you'd like us to do a deep dive on, if there's a topic that you want to know more about, or if you have a question, if there's something in either Baldoni's filings or Lively's filings that you're like, I don't know about this, I would like to know more, drop it in the comments, and we can absolutely use that as time to go do a deep dive on that question next week. And I will absolutely love that. Thank you, everybody. Appreciate, again, you showing up. Thanks for lasting out for as long as you did. Appreciate the support. Thanks for keeping me company, chat. Like I say, we'll do it all again next week. If you like what we're doing, like, comment, share it with other people so that they get to see it. In the meantime, I will see you all over Threads for the rest of the week, and then we'll do this again next weekend. Hope you have a great rest of your evening, whatever you're doing when you watch this, and have yourselves a great weekend. Thanks again, chat. Appreciate you.